Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is Baptiste versus the state. Counsel for the petitioner.
Thank you, Mr. Chief Justice. May it please the court. My name is Shannon Hemmendinger, Assistant Public Defender on behalf of Mr. Baptiste. I'll reserve 5 minutes for rebuttal, please. Your Honors, trial judges have a responsibility to make sure that jury verdicts are not the product of undue coercion. A coerced verdict is antithetical to our Constitution and how our adjudicatory system is supposed to operate. The question in this case is whether trial counsel could waive a claim of jury coercion by agreeing that the jury should be ordered to fill out new verdict forms following not only the failed poll, but also multiple prior indications of deadlock. This court should conclude that where the totality of the circumstances demonstrate that a jury was coerced into reaching a verdict, fundamental error has occurred and defense counsel cannot waive this error. Defense counsel should not have the power to waive an accused's right to an uncoerced verdict or a jury's right to be free from coercion. Your Honors, under the unique and highly coercive circumstances of this case, the only option for the trial judge upon learning that the initial verdict was not unanimous was to declare a mistrial. There was no other lawful course of action for the court to take, given everything that preceded the non-unanimous verdict.
So is it your position, counsel, that the provision of Rule 3.450 regarding polling the jury, in particular the provision that says if a juror dissents, the court must direct that the jury be sent back for further consideration is itself unlawful?
No, Your Honor, not arguing that that provision itself is unlawful, but that provision, that rule must be read in conjunction with the cases prohibiting a coerced verdict. If we did not have all of the prior notes indicating deadlock and 2 prior Allen charges in this case, and simply the failed poll, then I would concede that Rule 3.450 governs. But when you have a situation like we have here with the repeated notes of deadlock and the multiple Allen charges, at that point, the law requires the judge to declare a mistrial. And that was recognized by the First DCA in the Cogman case that we cited in the reply brief. In that case, the jury had received 1 Allen charge. Polling revealed that one of the jurors did not agree with the verdict. And the First DCA, citing to Rule 3.450, noted that the only option for the judge in that case was to declare a mistrial following the failed poll.
So I'm clear. So I'm clear because this situation occurred in my courtroom a number of times when I was a trial judge. So I try, let's say I preside over a 2-week-long homicide case or robbery or burglary or whatever, and the jury deliberates for whatever long, and I get a note saying they're deadlocked, and I go ahead and read the Allen charge, and they go back and retire to the jury room and deliberate longer, and then I get a note saying they have a verdict. So I bring them out, and the verdict is published. Then I ask the clerk to poll the jury. Juror number 1, yes; 2, yes; 3, yes; 4, no; 5, yes; and 6, yes. So at that point in time, there's only been 1 Allen charge. So I guess it depends on what I say as a judge at that moment as to whether there's a second Allen charge or not. What if I do what was done in Ruby, where the judge, or what was done in this particular case, actually, where the judge basically said there isn't a unanimous verdict. Jury returned to the jury room and continue deliberations. Is that regarded as an Allen charge, a second Allen charge?
What the judge gave in this case, Your Honor, it was not a
No. What I just did hypothetically. Ladies and gentlemen, there isn't a unanimous verdict. Please return to the jury room and continue deliberations, and they'll get a blank new verdict form. Do you regard that to be a second Allen charge?
I would, Your Honor, because of Your Honor's request to the jury to continue deliberating. But even without that language, the please continue deliberating language, I think we could still get to the conclusion that that would be a request for continued deliberations. Now, the facts in your honor's hypo are slightly different and certainly not as coercive as the facts of this case, and it would be a much closer call. But I think if your honor had presided over a trial and a jury sent a note indicating they were deadlocked, and then the poll revealed that they were still not unanimous, I think Cogman would require a mistrial at that point. But when
all the judge did in this case was say, basically to the jury, you had, if you have he sent them back, basically told them, if you have a unanimous verdict, fill out the form. If you do not have a unanimous verdict, please knock on the door and we'll bring it right out. I mean, how is that coercive?
Because, Your Honor, we have to look at the language of the final charge in the context of everything that took place prior, and we have to analyze the final charge for the effect that it had on the jury. Everything that took place prior, this jury, almost immediately after beginning deliberations, told this court they could not reach a unanimous verdict. At least 3 times, or at least 2 times, they sought to replace the holdout juror. One of the notes even indicated that the juror himself was willing to step aside so they could render a 5-person verdict. Each time this jury told the court they could not reach a verdict, the court told the jury to try again. First, by asking them to continue deliberating.
Ms. Hemmendinger, if I could ask you a question. So I think you're conducting and running us through a very appropriate, in some cases, review to determine whether there was a coercive verdict. I'm going to ask you, though, didn't counsel request and then agree to the instruction that was given that you're objecting to on appeal?
He did, Your Honor, yes.
And
Defense
then
counsel did agree it should be given.
I'm going to quote from Universal Insurance Company versus Warfel from this court. Fundamental error is waived where defense counsel requests an erroneous instruction or affirmatively agrees to an improper instruction. And so my question is, why would we on appeal, or the lower appellate court on appeal, even conduct that fundamental error analysis to determine whether it's coerced, the verdict is coerced, when the fundamental error analysis was waived by counsel's actions below?
Because, Your Honor, Your Honor's reference to the Universal case, those cases, all of the invited error cases cited by the state in their answer brief, and all of the invited error cases that I'm aware of involve normal trial error, normal instructional error, or normal evidentiary error. They do not involve this type of error involving a coerced verdict. A coerced verdict is so egregious and so perverse to our adjudicatory system that we cannot allow them to stand regardless of what any litigant asked for in the trial court. It is the responsibility.
And where are you quoting from, or do you have a cite from this court for the proposition that there is no possibility of waiver in this particular context?
Not from this court, Your Honor, but I would cite the court to the Fourth DCA's decision in Ruby, which the only difference between Ruby and this case are that the facts of this case are far more coercive than they were in Ruby. But in Ruby, defense counsel did ask for the erroneous instruction, affirmatively agreed that it should be given, and the Fourth DCA recognized that a constitutional error of this type resulting in a coerced verdict cannot stand regardless of counsel's request for the instruction. Ruby is the only case I'm aware of that so holds, Your Honor, but I think the fact that we don't have any more case law on this point demonstrates 2 things. First of all, that this issue doesn't occur very often. And second of all, that when it does, trial judges know that they are supposed to, when confronted with a situation like this, which is a clearly deadlocked jury that has already been given multiple Allen charges and is still unable to—
Let me just challenge, given that we have the opportunity for affirmance without opinion in Florida, I'm interested in how you can conclude that this is a rare instance. I mean, it could be that all the other appellate courts have just applied the rule that fundamental error is waived on appeal when the instruction that's requested is requested by defense counsel and agreed to by defense counsel. So there could be thousands of cases, correct, where the same facts happened, but it was just affirmed, right?
It certainly could be, Your Honor, but we do have Ruby,
and you would agree that the Fourth District in the case, that the conflict case, did not follow our precedent on invited error in this context, correct?
I would agree that Ruby stands for the proposition that defense counsel can agree to an erroneous Allen charge and that does not waive the issue. But I'm not sure that this court has any precedent on point. I'm not sure.
Did they conduct any kind of analysis to explain why the invited error doctrine should not apply in this context?
Your Honor, if we look at the opinion in Ruby, they lay out all of the issues surrounding a coerced verdict, and they explain why coerced verdicts are so antithetical to our justice system. And then at the end of that opinion, they conclude that because of all those reasons, defense counsel cannot be allowed to waive them. And I'm not sure that there's any opinion from this court that holds that a coerced verdict is okay as long as defense counsel asks for it. The rule must be that defense counsel cannot ask a judge to coerce a jury into reaching a verdict.
Then counsel, I wonder why not then have the courage of your convictions on that and remove the totality of the circumstances qualifier from your argument? Because when you started, your argument was on these very narrow facts, on these total circumstances of this very coercive fact pattern, you should hold that there cannot be waiver. But as today's argument has unfolded, it appears that you're proposing a much brighter and more aggressive line, which is no waiver under these circumstances. Why not just jettison the totality of the circumstances argument then?
We have to analyze the totality of the circumstances to determine whether in fact there has been a coerced verdict. And when those totality of the circumstances so demonstrate.
So let me test you on that then. What's the role of this court? When then is there a totality of the circumstances that renders a represented party's intelligent and knowing waiver on the record? Tell me how we get into that business successfully as a court. What are we supposed to do?
This court is supposed to, Your Honor. In this case, the issue is, can defense counsel waive this? We have a record demonstrating that the jury was coerced into reaching a verdict, and the Third DCA rightly settled that question below. The sole question before this court is, can defense counsel waive that? And the answer to that question must be no, Your Honor. And this is because the integrity of our justice system, our whole adjudicatory system, quite frankly, demands that a jury be able to reach a verdict without undue pressure or coercion from the court. Juror coercion infects the integrity of the fact-finding process, Your Honor.
With those principles, I guess you'd concede, wouldn't you, that this would be a better case for you if counsel hadn't waived, right?
Absolutely.
Okay, all right. So if that's true, then I guess the logical sort of question before us is, what impact does that waiver have? How would your case be better, right? And can you explain for us what impact we are supposed to give to that knowing and intelligent waiver by a represented party?
Certainly, Your Honor. Had counsel objected following the failed poll and moved for a mistrial, the court would absolutely been within his discretion to declare a mistrial in this case. In fact, he was required to declare a mistrial regardless of counsel's failure to ask for one. The fact that counsel failed to ask for one, however, should not preclude this court from issuing an opinion in Mr. Baptiste's favor. I understand the court's concerns about invited error, and we're not asking this court to at all recede from the invited error doctrine. But what we are asking this court to recognize is that this particular class of error, and a coerced verdict, is so egregious and cannot stand no matter what any litigant asks for in the party. This goes beyond counsel, and this goes to the job of the trial judge to prevent all of this from happening. So while I absolutely agree it would have been better for counsel to object, and while counsel should absolutely still be encouraged to object, that does not change the analysis here, because defense counsel simply cannot ask a judge to do what they did in this case. A trial judge has an obligation to prevent all of this from happening. And because the judge failed to do that in this case, this court must conclude, despite counsel's affirmative request for this erroneous instruction, this manslaughter verdict was nevertheless fundamentally erroneous. And I would note that this court's opinion in Thomas even stated that jury deliberations.
I know the Third District said this, but I'm curious as to why a mistrial motion, if one was made, would ever be properly granted when the information if it was evidentiary, but when what happened would happen because the party who would move for the mistrial invited it to happen. In other words, if you were a defense lawyer and you were questioning your client and you asked him, have you ever been convicted of a crime? Yes, how many? And what were the nature of those crimes? And they were exactly the same as what he was charged with. So he's here for burglary. He's had 20 felony burglary charges. Could counsel then move for a mistrial and say, Judge, I mean, it's fundamental. There's just no way that I can have a fair trial for my client now because, you know, the law is really clear that the jury can't know the nature of prior crimes. And it's even more prejudicial when they're, I mean, I'm struggling with the notion that you can even have a proper mistrial motion for something that you've done and invited knowingly and intelligently. Explain.
Well, Your Honor, the mistrial motion should have been made in lieu of the request for the final charge. Had this gone the way it should have, and seeing that I'm into my rebuttal time, I'll briefly answer Your Honor's question. Had this gone the way it was supposed to, upon this final poll, one of two things should have happened. Defense counsel should have said, Your Honor, I move for a mistrial because this jury is incapable of reaching a unanimous verdict. Or the judge, upon hearing defense counsel's request for continued deliberations, should have said, no, I cannot allow this jury to continue deliberating, and I cannot allow this jury to go back and fill out new verdict forms. Going back to your earlier question, Justice Labarga, it doesn't matter that the judge did not give a formal Allen charge, did not order them to continue deliberating. We know that's what they did because at least five of them changed their verdict. The only thing the judge should have said was mistrial, please go home. And because he failed to do
so, I understand your position clearly because, I mean, obviously, whatever we write in this case is going to be instructive to trial judges who are faced with this and don't know what to do once you get that one juror saying no. So I'm clear. Your position is that once a juror says no, this is not my verdict during the polling, the only option a judge has at that point is to declare mistrial.
If that judge has already given an Allen charge, and if it appears to the judge that no other course of action is possible, then yes, at that point, it would be manifestly necessary for a judge to declare a mistrial.
What would have previously given an Allen charge? Why would that make any difference?
Because after giving an Allen charge and having a failed poll, the likelihood becomes that any further instruction is inherently coercive and will result in a coerced verdict. And because that's exactly what happened in this case, the only option for the court upon hearing the final verdict and everything that preceded it, all of these notes of deadlock, all of these all of these requests to expel the sole holdout juror should have told this court that there was nothing he could have instructed them that would have helped them reach a unanimous decision. It was manifestly necessary for the judge to declare mistrial at that point, and his failure to do so resulted in an unconstitutionally coerced verdict. And if I may, I'd like to reserve the rest of my time for rebuttal.
I do have one more question, but as I'm thinking about how this would have played out if the judge had, over defense counsel's objection, individually, personally declared a mistrial when defense was arguing, Judge, I'm about to get a not guilty. Wouldn't the argument have been first below and then on appeal? This is double jeopardy. The judge, I had a right to waive this. And a judge can't declare a mistrial over my objection without violating, and then the state can't try me again. That's clearly double jeopardy. Wouldn't that have been the argument?
I don't think any defendant would be able to successfully claim that a mistrial wasn't manifestly necessary under these particular circumstances, Your Honor. I don't think that manifest necessity would preclude retrial, or double jeopardy would preclude retrial here, because it was obvious that no further instruction would have resulted in a unanimous, uncoerced verdict. So I don't think that the defendant could have tried, but I don't think that would have been a successful argument either in the trial court on retrial or on appeal. Thank you, Your Honors.
All right, counsel, I'll give you a total of 3 minutes for rebuttal.
Thank you.
All right, counsel for the state.
Thank you, Mr. Chief Justice, and may it please the court. There are three paths to uphold the verdict here. The first is to hold that there is no error because in context, the trial court's neutral and balanced charge following the failed poll did not create a serious risk of coercion. The second is to hold that petitioner's counsel invited any error by both suggesting and then twice agreeing to the challenge charge, and that consistent with over 170 years of precedent, including precedent from this court, petitioner's counsel was authorized to make that tactical decision. And the third is to hold that any error in this case was not fundamental. All three paths lead to the same place. Mr. Baptiste's convictions should not be disturbed. And let me start with the argument that the charge here was not coercive. And I'd like to begin, if I could, with the legal test, which comes from Thomas and LeBron. And I'm quoting here, both cases ask whether the facts and circumstances surrounding an individual case combine to create a serious risk of coercion. And that's a high standard. We're not asking whether there's any risk of coercion, whether there's some risk of coercion. We're asking about a serious risk, and it's a high standard for a reason. And that reason is we will never actually know whether the jury was in fact coerced. We do not get to be in the jury room. And so we don't want to be disturbing otherwise valid verdicts unless we're pretty sure that something improper has happened. And I think that standard also reflects the fact that trial courts are closer to the facts on these issues and therefore better able to observe the jury for coercion. And when the trial court thinks that there's unlikely the verdict was coerced, appellate court should very rarely be granting relief. Now, we don't think that Mr. Baptiste can make the high showing of showing a serious risk of coercion, and let me explain why. And I think the first part of that explanation comes from the fact that this is a jury that was told that it was permissible to reach a hung jury and that a mistrial would be granted. Petitioner's counsel makes much of the fact that this jury had repeatedly deadlocked, but I think that the judge properly responded to that deadlock by reading an Allen charge, which this court has blessed. And in that Allen charge, the judge said, and I'm quoting from page 2284 of the transcript, "If you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried, and you will just be discharged with my sincere appreciation for your services." So this is a jury that we...
Isn't there also, counsel, in the record, evidence that all the other standard instructions were given and that we should presume that the jury heard and understood and followed those, like from the beginning of the trial, about what jury deliberation would entail?
I think that's exactly right. We have very little doubt that this is a jury who properly understood their role and properly understood that a mistrial was a permissible outcome. And then the jury is discharged following the Allen charge, and they deliberate for 2 hours. And I think on our view, what that deliberation indicates is a jury that is functioning and has responded to the Allen charge by deliberating. The jury then announces a verdict, but one juror dissents from the poll. And we think that the proper frame of analysis there is to ask whether the judge's response to the failed poll would have disabused the jury of the instruction given 2 hours before that a deadlock was permissible. And we don't think it did. Instead, on our view, the judge's response to the failed poll gave the jury the chance to clarify the failure while allowing the possibility of a mistrial if the jury remained deadlocked. And let me explain why. The first point, and I didn't hear a lot of discussion of it this morning, is that the language of the charge did not demand a verdict. The judge said, and this is at page 2296 of the transcript, "Please fill out the verdict form. If you have a unanimous verdict, please fill out the verdict accordingly. If you do not have a unanimous verdict, please knock on the door and let the bailiff know. We'll bring you out back here." 2 features of that charge communicated to the jury that a verdict was not required. First and most obviously, the judge told the jury that if they didn't have a verdict, they should knock on the door and come out for further instructions. And the second thing is that the judge used conditional language. He says, if you have a unanimous verdict, which implies the possibility that the jury does not. Now, counsel for Mr. Baptiste cites Cogman and says that Cogman would have required a mistrial. But I just don't think that Cogman requires as much, because the problem in Cogman is that following the failed poll, the judge never sent the jury back. And if you look at the very end of the decision, what Cogman says is Juror Searcy, having dissented from the verdict and there having been no subsequent unanimous verdict, a mistrial should have been declared. The error in Cogman was not that the jury was sent back with new verdict forms. The error in Cogman was that the jury was not sent back at all, and thus there was no unanimous verdict. And so I think on this record, what the judge did following the failed poll was entirely proper. He said, look, we know that this jury announced a verdict. I want to give them an opportunity to explain why the poll nonetheless failed. Now, Mr. Baptiste's counsel insinuates that there should have been no further discussion at that point, because on her view, the only thing that this jury had communicated was that they could not possibly agree. But we just do not think that that follows from the failed poll. And I direct
Counsel, I apologize for interrupting you, but can I just ask you, just sort of from a big picture perspective in terms of what value this court can add to these issues? So obviously, if the court takes the path of kind of solidifying the rule and applying it in criminal cases, saying that invited error just is kind of per se ineligible for going through all the fundamental error analysis, it's obvious that that would be, you know, a valuable precedent. You know, it transcends the particular issues in this case, this, you know, the type of claim, the facts, whatever. If the court goes down the path of ruling in your favor kind of on the substantive issue that's presented here, what is the, you know, it seems like there's so many variables and you're getting into sort of the precise wording of what the judge said and what had happened with the jury before. And I kind of wonder what kind of precedential value this would have for other cases. And so if the court does go down the merits path, is there, you know, what is the sort of larger principle that from the state's perspective you would be looking to have established?
I think that's a great question, Justice Muniz, and let me give a few pieces that we think that the court's precedent could establish here. The first is we think that it would be useful to get an opinion from this court clarifying the legal standard and noting the high standard that needs to occur before a jury verdict is reversed for the risk of coercion. The second thing, as the court saw in the briefs, there is currently a split going on between the district courts of whether there is a per se rule that you can never have a second Allen charge. And we've explained in our briefs, we think that's the wrong analysis. I think petitioner agrees now that that's the wrong analysis. And so we think a decision from this court clarifying that rule would also be helpful. I mean, I do want to get to the first premise of your question. We also agree that it would be very useful to get an invited error precedent from this court. But I think as the court recently did in, for example, the Dortch opinion, the court could say something about the merit standard and then move on and apply invited error or vice versa. And so I think that we would welcome the court's clarification of the standard in a coerced verdict case. And we do think it'd be helpful for the court to apply that standard because it would give lower courts a chance to see how that standard works in action. Now,
and so can I ask you about fundamental error? So if you think about kind of what the whole fundamental error doctrine is for, why, and I understand the sort of the appeal of if we're going to have to draw some lines, there's kind of a common sense sort of intuitive distinction between, you know, sort of a counsel kind of passively allowing error to happen versus this, you know, counsel asking for something that's arguably erroneous to happen and then complaining about that very thing on appeal. But if you think about what the fundamental error doctrine does systemically, why, and I think your counsel on the other side, this was some of what she was getting at, why should there be a difference between passively allowing error to occur versus being part of why the error occurs in the first place? If fundamental error is really getting at the idea that it's not about the defendant's rights and there are certain kind of overall systemic values that we care enough about that we're willing to entertain claims of error, regardless of, you know, the lawyer not doing his or her job at the trial level.
Sure. So I think that there's two things I would say on that. The first is inherent in the invited error doctrine is the idea that there's been some affirmative action. And I think that commission versus omission line does matter. And it matters because we tend to think that counsel is doing a good job defending their client's interests and are acting effectively. And so when counsel is asking for a charge, we think that it's very unlikely that that charge is going to impugn the entire judicial system at a systemic level. And then the second point, and this is the point that's made by this court repeatedly, including in Warfel, is that it just becomes unadministrable if counsel can introduce errors into proceedings and then get it reversed nonetheless. And I think this case would be a very good example of that. If counsel could introduce the error here, counsel could say, send the jury back, please, as many times as you want, because counsel would know that any verdict will be reversed. There's no incentive to not keep asking because maybe he gets an acquittal. And if he doesn't, he knows that the verdict is going to be reversed on appeal. And that's why in Warfel, this court said, and I'm quoting now, fundamental error is waived under the invited error doctrine because a party may not make or invite error at trial and then take advantage of the error on appeal. I think we would set up a very perverse judicial system if counsel could introduce errors into proceedings and then nonetheless benefit from them. It would turn the incentives on its head and would allow lawyers to benefit from their own errors, which would incentivize trying to get trial judges to make those errors.
Would this be a better case for you if the court had colloquied Mr. Baptiste on the subject that is at issue here?
So I think there'd be no doubt that the case would be better for us. This court has repeatedly said, even when it doesn't require personal colloquies, that trial judges always have the discretion to have a colloquy. And if you do, you basically eliminate any claim whatsoever that the waiver was not knowing intentionally. I don't think that it really matters. I mean, if you look at the transcript in this case, what you see is that counsel is asked how they should proceed following the failed poll. Counsel consults with Mr. Baptiste and then proposes the charge that's being challenged here. And so I don't think that there's really any argument that this was not a knowing and intentional waiver. And all that leaves is petitioner's legal claim that this was a required personal colloquy right. And I just don't think that the court should endorse that type of reasoning, as no court in any jurisdiction in the country has ever done so. And I think that that view is also inconsistent with this court's precedent. So I think this court has already accepted counsel waivers in cases like this one in the Bryan case. In Bryan, the defendant argued that it was error to give an Allen charge under the circumstances. But nonetheless, in Bryan, the court assumed that it was error arguendo, but then at page 484 of the opinion, and I'm quoting now, said, choices of tactics are for the trial lawyer, but he becomes bound by the result of the choice he selects. And I don't see any reason why Bryan should have been bound by his lawyer's decision, but Mr. Baptiste should not be bound by the same decision. And so, I think that was a little bit of a long-winded way of answering your question, but at the end of the day, I just don't see any way for the court to conclude that this is one of the very few personal waiver only rights that would have required Mr. Baptiste's assent. And in fact, as we cite in our brief, no court has ever held that, and every court to consider the question has come out in the opposite way. Now, the only case that Mr. Baptiste cites on this is Ruby, but I don't think that Ruby even gets close to discussing the issue. You can search Ruby upside down and backwards. You will not find any discussion of either invited error or personal colloquy. I think the problem in Ruby, and this is very apparent if you look at page 635 of the opinion, is that Ruby treated it as a failure to object case. It is true the Ruby court notes that the defense lawyer requested the charge, but then Ruby says we see no reason that the defendant should not be bound by his lawyer's failure to object. And Justice Lawson, I think this goes to your question. Ruby just does not consider at all this court's invited error precedent. So I think, as we explained in the beginning, there are three ways that the court can go about upholding the convictions here. We don't think there's any coercion on these facts. The judge gave a balanced charge that allowed the jury to clarify its verdict. I think it was apparent at the time that the jury was engaging in good faith deliberations. They deliberated for 2 hours following the Allen charge, and then they actually announced a verdict, which I think is very inconsistent with the deadlocked jury. But even if the court doesn't want to go down that route, we think that any error in this case was invited, and we don't think that the court should carve out a new constitutional rule that requires a colloquy before a personal waiver of this type that has never been endorsed by any court anywhere in the country, and that even Mr. Baptiste did not argue for below. If there are no further questions, I'll yield the balance of my time.
Rebuttal argument.
Thank you, Your Honors. Your Honors, there can be no question the verdict in this case was coerced. 4 times, this jury told the court it could not reach a verdict. As soon as juror number 5, who initially agreed that he would go with second-degree murder, was taken out of that isolated jury room and brought back into the supervised courtroom, he told the court, "This is not my verdict." By sending the jury back in, only to fill out new verdict forms, which I know counsel for the state says was a fair and balanced charge, there was nothing the court was going to learn from having the jury fill out new verdict forms that it hadn't already just learned by the poll. It already knew that this jury was not unanimous and that juror number 5 did not agree with the poll. The fact that the jury deliberated for 2 hours after the Allen charge is taken out of context when we consider that the final manslaughter verdict was rendered just 10 minutes after this instruction to go back in and fill out new verdict forms. I think this record clearly demonstrates, and the Third DCA agreed below, that this final instruction was the but-for cause of the manslaughter verdict. As to the state's point about incentivizing defense counsel to inject error into the trial and then take advantage of that error on appeal, this comes back to the job of the trial judge. Had the trial judge done what the law required of him and declared a mistrial following this failed hold, then there would be no error to take advantage of on appeal. This rule does not encourage gamesmanship. It encourages trial judges to continue to protect the jury and the system from coercion. Your Honors, this case goes beyond an Allen charge. This case goes even beyond my client. As Justice Muniz noted, this case is systemic. It affects our juries. It affects our system as a whole. We cannot allow juries to be coerced into reaching a verdict. It is the sole obligation of the trial judge to keep that from happening. And because the judge failed to do that in this case, my client's manslaughter conviction was unconstitutionally coerced. The jury's most inviolable right to remain free from coercion was violated. We would ask that this court quash the decision of the Third DCA, rule that defense counsel cannot ask a court to coerce a jury into reaching a verdict, and rule that my client be given a new trial. Thank you.
Thank you, counsel. We thank you both for your arguments in this case today. And the court will now prepare to take up the second case on today's docket. Hear the case of Walters versus the Agency for Healthcare Administration. Counsel for the petitioners recognized.
Good morning, Chief Justice Kennedy. May it please the court. I am here on behalf of the petitioner, Pauline Walters, personal representative of the estate of Enid Townsend. Your Honor, this matter before the court, we can take this back to the founding of this country, when in 1868, the Constitution of the United States was formulated, and Florida has followed the constitutional guidelines of the United States, and in 1862 established Homestead Act. The Homestead Act has been carried on over the years, and in Article 10(4) of the Florida Constitution, the homestead protection is provided to the citizens of Florida. Ms. Townsend, as a citizen of Florida, believes that she had an entitlement for her homestead apartment, which was a cooperative apartment, to be given the status of a protected homestead under the Constitution. That is under Article 10, A1. The petition was denied by the trial court following the precedent of this court in Wartels, which was heard in 1978. Wartels was heard in 1978 following a number of cases that had rendered opinions that was inconsistent with the opinion in Wartels. Petitioner asked that the court recede from Wartels and quash the Third District Court of Appeals decision and reverse the trial court.
Counsel, I'm sorry to interrupt you. Could you tell us why, assuming that we were willing to entertain revisiting Wartels, can you point us to something in the text of the Constitution that makes Wartels clearly erroneous, which is our test for when we would receive from a precedent, or what, at least the threshold question?
Well, Your Honor, Justice Lawson, thank you for the question. I believe it was your opinion in State v. Cool that laid out the requirements for receding from precedent. Also in looking at the Constitution, the plain language of the Constitution, which is the guideline we're supposed to follow if we, again, referring back to the court's decision in Zengale v. Powell, we have to look at the plain language of the statute of the Constitution, and the plain language of Article 10, A1 states that the requirement for determining whether a property is protected homestead requires only that the property be the permanent resident of the homeowner, that it be owned by the homeowner, and that it meet the space and physical location requirements. And the petitioner contends that her property met these requirements.
And how do you, so I understand that property is a word that is sometimes used to describe sort of a bundle of rights, but that it also is used to refer to the actual thing that is owned. And it seems like so if you accept there's an ambiguity, then it's hard to get into it's hard to meet a sort of clearly erroneous test. But if it seems like the sense in which this constitutional text is using the word is in terms of the thing owned, not in the bundle of rights sense. And if you're talking about the thing owned, I mean, isn't it clear under the Cooperative Act that it's the association that owns the apartment and not the unit owner, the unit holder?
Your Honor, under the Cooperative Act, the shareholder has a proprietary interest in the corporate apartment. This is something that seems to be eluding the discussion on this issue. The real property that was involved here, which is what the petition was for determination of the homestead status of the real property, not the stocks that was owned by the shareholder. In petitioner's brief, we analogize the brief to a deed. A deed is a personal property because it's chattel paper. the interest purchased or the deed evidences the existence of the real property. We do not make a determination as to whether the property is real property by looking at a deed. In the case of a cooperative, the cooperative apartment is essentially purchased, and evidence of that purchase is the shares of the corporation. The AHCA confuses the issue of the existence of the stock, which is how the legal title of the property is described in the petition, because that's how it's held. It's held by
Mr. George.
Yes.
I'm still looking for an answer to Justice Muniz's question as to if you could point us to the language in the Constitution that would indicate that Wortels was clearly erroneous in its interpretation of the Constitution. That would be helpful. And if you don't, just say that it's not there. That would be helpful.
Your Honor, thank you for the question, Justice Lawson. I think I erroneously called Justice Muniz Justice Lawson. The clearly erroneous factor would be that there is, at the time that Wortels was heard, the Florida statute had enacted Florida Statute 719. Florida Statute 719 was part of an overall scheme which moved the cooperative and the condominium from under Florida Statute 711 into Florida Statute 718, Florida Statute 719. And Florida Statute 719.102 specifically states that the purpose for establishing this was to recognize that a cooperative was real property. So when we read Article 10.4 A1 of the Constitution, and we talk about property in Florida that is owned by the homeowner, we are talking about real property with regards to cooperative. Now,
okay, I think I see where you're coming from then. So then the question might be adjusted to what language of the statute can you point us to and maybe read for us that says that the person that has the cooperative interest in the unit is the owner of the real property? Because I think as Justice Muniz's follow-up question indicated, I mean, I read that statute and it fairly clearly says that it's the association that owns the real property. So are you suggesting that that's not what the statute says, or there's a more reasonable reading?
The statute says that the property is owned by the corporation, because that is the manner in which the property interest is acquired by the cooperative unit owner. And there is pending legislation, which I believe at this point has been passed, since the governor has not signed it or acted on it within 15 days from when it was issued on April 27th. So effectively, as we're speaking, the statute change that puts that language into 719 is there. But the argument raised in the brief, notwithstanding the fact that the legislature has now made it essentially remedially showing what the intent was when 719.102 was enacted. Now, 719.102 said that the cooperative should be recognized as real property. And it says except and is repealed on except for any law inconsistent with that as it relates to cooperatives. So the cooperative is also described in 719.103.12 as the ownership of real property wherein legal title is vested in a corporation or other entity, and the beneficial use is evidenced by an ownership interest in the association and a lease or other monument of title or possession granted by the association as the owner of the cooperative property. So within that definition, it tells you that the corporation owns the building, but the unit owner has a possessory interest through a lease or some other monument of title. In this case, the petitioner is a unit owner and with a long-term lease, an ownership interest that has resulted in, as has been produced to the court. In order to get back possession of that property, they had to foreclose on her. That property was placed into foreclosure, and as the brief reflects, and the request for judicial notice has been provided to the court, showing the actual petition to the probate court.
Counsel, let me take you back to the issue of precedent and Wartel's estate, which obviously is a problem for your position. But let me ask you, isn't it, if I understand your argument, isn't it important to your argument that Wartel's did not engage with existing precedent, which had held that a beneficial interest in land and property was sufficient to establish homestead?
Yes, Your Honor. Thank you, Justice Kennedy. And I did cite to Pasco, Hill, and Milton. Those are cases that were heard in 1917 and 1912.
And interestingly, that some of those cases that refer to beneficial interest are actually cases that are cited in Wartel's without any discussion or any explanation of why the reference to beneficial interest is not significant. So it's your position, isn't it, that if a precedent such as that, which is not engaged with other precedent, because those precedents are still out there, they've never been overruled that I know of. If I'm understanding correctly, it's got to be or maybe I haven't understood. I'll ask the other side, but it seems like that they're inconsistent with what Wartel's decided, although Wartel's did not address them. So doesn't that undermine the value? Isn't it your view that would undermine the value of a precedent if it doesn't engage with the precedents that were in place when it was decided?
Your Honor, that's a decision I would like this court to make on behalf of the client. And this is a position that the petitioner has taken. If you look at Wartel's came up from the Third District Court. And the specific language in the Wartel's was that the interest was not involved in a cooperative, was not an interest in land. So when the court received Wartel's, when this court received Wartel's, reviewed Wartel's, they looked specifically at the language cited by the Third District Court of Appeal, and this was focusing on Ammerman, and looking at Ammerman with regards to the application of the tax benefit, in which the tax benefit under Article 776, they determined that the property was considered real property, which is an anomaly as far as the petition is concerned, because if the property can't be real property one day for tax purposes, and then the next day it's no longer real property, it's now considered something other than real property. So
Counsel, you are now burning up your rebuttal time. I just want you to be aware of that.
Okay, I'm just going to quickly get back to the specific question that you asked. The focus in Wartels when it was decided was on the issue that a cooperative was not an interest in land. So in looking at Pasco Hill and Milton, what the court did was just use those cases for the purpose of showing that it has to be an interest in land. But the Constitution only says an interest. It does not define the extent to which the interest is, which was well laid out and argued in Southern Walls as well as in Jurassic.
Mr. George, you're asking us to find an interest in real property on behalf of your clients, even though they don't have the deed. The deed goes to the co-op. That same type of argument is commonly found in property tax for equitable ownership type arguments where the taxes accrued to those who have equitable ownership. Does the record reflect that your clients, those who have interest in the co-op, actually receive any type of property taxes, assessments from the property appraisers?
Your Honor, the record may be deficient in that regard, other than the petition that was filed. The court, relying on the position in Wartels, based on the objection of AHCA, determined that the property was not qualified because it was not an interest in land, which was the objection from AHC. That it was not an interest in a fee simple interest in land. So we never had an opportunity to present any thing to the court beyond what is filed in the petition, and the petition alleges that the property was her homestead, that she owned the property, and that is determined in the area of probate. That is determined to be sufficient without more to determine whether the property was homestead.
Thank you.
All right. We will now hear from the respondent.
Thank you, Mr. Chief Justice. May it please the court, Alexander R. Bowler on behalf of Agency for Healthcare Administration. I want to start with the petitioner's last argument regarding what our Constitution says about what is protected homestead property. Article 10, Section 4 of the Florida Constitution lays out a limitation on the definition of homestead property, explaining that a homestead, if located outside a municipality to the extent of 160 acres of contiguous land and improvements thereon, or if located within a municipality to the extent of 1/2 acre of contiguous land. While the Constitution does not define exactly what is homestead, it does place these limits on it. It must be a certain number of acres of contiguous land. A interest in a cooperative apartment owned through corporate stock is not an interest in acres of contiguous land.
Well, it certainly is certain. You can't have a homestead without a physical place, right?
Yes.
It's kind of intrinsic to, at least in the current status, the current condition of human life, we have to have a physical place to call home. Is that correct?
Yes, Your Honor.
So isn't it the case that we have precedents that say that you can have a homestead without having a legal title to the property?
Yes, for example, the Bessemer Properties case in which a wife owns the legal title to the land and her husband had an equitable interest in the land because of the improvements that he made upon the land. So he did not hold the deed. He was not the legal owner. The wife was the legal owner. You'll see this with trusts as well. A trustee is the legal owner of the corpus of the trust, but there's a beneficiary who is the beneficial owner. That is an area of equitable law. That's part of our common law. That is wholly different from what this is, which is corporate stock, a corporation, a a legal person wholly separate from a natural person owning the land. And in turn, Ms. Townsend in this case and others who own corporate shares of stock own that legal entity. It could keep going. You could have another holding company that owns a corporation. So there's no stopping if it's not a natural person who owns the land.
Well, it's a natural person has to claim the homestead. Isn't that what what the law is? Obviously, only a natural person can have a homestead.
Right, and only a natural person can be the decedent.
Well, I thought you said that if the trust owns the land, trust is not a natural person, is it?
No, a trust is not.
A trust owns the land, and there's and the person who's established a homestead has a beneficial interest in the land as a result of the trust. Then you recognize that there's a law that says that can be a legitimate homestead, right?
Yes, and that's very similar to the Bessemer Properties case.
So that the principle that a natural person must own the land kind of goes by the way.
Well, can I ask you though, counsel? So, I mean, obviously one question is, how does Wartell square with those older precedents? One answer to that is Wartell's was a very specific, cooperative focus. The older precedents are dealing with very different fact scenarios. But the real question is, the governing law here is the text of the Constitution. The Constitution says the following property owned by a natural person. So I think the question really arguably could be, how do the older precedents where it's talking about beneficial interests and whatever, how does that square up against the constitutional text? So in other words, if you look at the Bessemer precedents and whatever, do those, are those, and they were written at a time when the constitutional language was different, but now the governing constitutional language is the following property owned by a natural person before you get to the homestead thing. So how do you square those precedents with that language?
I'm not going to tell this court that Bessemer was correctly decided, but assuming it was, the equitable interest is an ownership interest. It's very different from what we have in this case, where a person owns a share of stock. The share of stock is not land. It's not contiguous acres. It is in ownership, in undivided ownership in a corporation. And the Cooperative Act, if I can talk about the Cooperative Act, it references the Florida statutes with regard to corporations and with regard to nonprofit corporations, and basically takes in what they have to say about management of corporations and how corporations are organized. So a cooperative association is really no different than any other corporation. And the Cooperative Act itself.
True. If that's true, then if we go to the constitutional text, as Justice Muniz just suggested, why aren't we in Section 4A2 and arguing that this is, in effect, personal property to the value of $1,000 and no more?
The petition for homestead estimated the value of the corporate stock at about $60,000.
I know, I get it, but I guess what I'm saying is, isn't a consequence of your argument that if you're right, then the value of homestead exemption that this cooperative share gives this person is no more than $1,000 protected by our Constitution. Is that not a logical consequence of the argument you're making?
Yes, it is, and I agree with that. So that remaining approximately $59,000 would not get the homestead protection. but the first 1,000 would.
Counsel, what if somebody had a long-term lease, a 100-year lease on a piece of property? I think that's pretty clearly been treated as equitable ownership for property tax purposes under other sections of the Florida Constitution and applicable statutes. Should they receive treatment as ownership in real property subject to the homestead protection and this provision of the Florida Constitution?
Well, the taxation provisions are completely separate.
I know, I just went through that. But is it for purposes, someone in that same position, hypothetically, or do they get the homestead protection?
For tax purposes or for?
No, the homestead protection under Article 10, Section 4.
Your Honor, I'm not sure exactly how the law should play out in that field. The courts I don't believe the courts have addressed it squarely. I don't believe this court has. The Third DCA has addressed it, and they found that a leasehold does constitute homestead property under Article 10, Section 4.
They said it does?
Yes, I believe that was a Garachi decision.
Okay, so is there any indication that this ownership in a co-op should be treated as a type of equitable ownership? Is it something that is long-term in nature? Is there anything in the record that indicates that one way or the other?
Well, what's in the record is the petition for homestead property, which describes the alleged homestead as corporate stock. And we know from the Cooperative Act and from the corporate acts in Florida that one can hold corporate stock in perpetuity. It's not.
I mean, it could be sold tomorrow. Is there any limitation on or restrictions on the ability to dispose of the cooperative stock in some way?
There may be. It's not in the record, but my understanding is usually there are some provisions that prevent somebody from just selling their interest without approval from the cooperative association.
Okay.
Can I ask you a question? And I'll preface this by saying this is a friendly question, but I'm curious what your answer would be, and I think it would be good for the court to hear your answer. So, if the court goes down the path of just answering the certified question, which is, does the passage of the Cooperative Act change the result in Wartell, sort of taking Wartells as a given and looking at the act, it seems like that's a slam dunk in your favor. If the court takes up the certified conflict issue, that is limited to the question of just whether this should be put in the basket of forced sale or whether it should be put in the basket of the devise and alienation provisions. And it seems like as long as we say that there's only one definition of homestead in the relevant constitutional provision, and then it doesn't really matter which basket you're in, it seems to me that you're also fine under that path. The only path that jeopardizes you is if we go back to the studs, we question Wartells, we start reading these cases from 1911 and whatever, and we say we've been looking at it all wrong in Wartells and whatever, and we're going to look at this conflict with the Southern Walls case and say Southern Walls is right, et cetera, et cetera. What is the reason from I'm assuming you don't want the court to go down that path, right? What would be the argument for why the court should not go down that path? And does the passage of this bill, that assuming the governor signs it, should that factor into how we look at this, look at that question?
Yes, Your Honor, correct on all 3 points. The certified question resolves in our favor. The certified conflict resolves in our favor. If this court wanted to go back to what the Constitution says and whether Ortels was correctly decided, the issue there is that you still have a form of ownership in which the person does not own contiguous acres of land. In Bessemer Properties and a few of the others, there was specific parcels of land owned by individuals, and in Bessemer Properties, it was probably the best example. It was a husband who made improvements on his wife's land, and the court found that those improvements gave him an equitable interest in the land. That is consistent, I believe, with our Constitution. It's not necessary to recede from either that or from Ortels. If there's nothing further, this court should affirm the probate court's order denying homestead protection, answer the third district's certified question in the affirmative, and reaffirm its precedent in Ortels. Thank you very much.
Thank you. Now we turn to the amicus.
May it please the court. I think I'll depart from my prepared remarks and begin answering some of the questions the court posed, specifically Justice Polson and Justice Kennedy. There is some confusion existing between Article 7 and Article 10. The case that we have before us is an Article 10 case on homestead. Article 7 relates to the tax exemption for homestead.
I'm not confused about it. I just want to know whether those same principles come in application in Article 10. I understand the distinction fairly well. What I would like to know is, maybe you can help me with my hypo. Does a 100-year lease get the Article 10, Section 4 protection?
It depends. May I read you a section of Article 7, Section 6 that will answer that question? About the fifth line down in subparagraph A, this is Article 7 of the Constitution, Section 6A. It says the real estate may be held by legal or equitable title by the entireties, jointly, in common, as a condominium, or indirectly by stock ownership or membership representing the owner or member's proprietary interest in a corporation owning a fee or leasehold initially in excess of 98 years. Specifically in Article 7 of the Constitution relating to the tax breaks that we get for homestead, a co-op is authorized specifically, and if it is based on a lease of at least 98 years, which I think answers your question. So your question, one question was under the tax, if there was a 100-year lease, would that be exempt homestead from Article 7 taxation?
No, that is it exempt under Article 10 as homestead?
And the answer to that is no. It's not exempt under Article 7. It's not exempt under Article 10.
Do equitable ownership principles apply in any respect under Article 10?
Yes, sir, they do. There are three types of ownership in Article 10. One is fee simple, that we all know and recognize. Another is tenancy in common, which is a fee interest in real property. And the what am I trying to say here? Tenancy in common. Oh, and the beneficial interest, as recited in Bessemer, is an interest in real property. You recall that Ortels said that the condominium and the cooperative failed because it was not an interest in real property. Well, a fee simple is an interest, a tenancy in common is an interest, a beneficial ownership in real property is an interest in real property.
What I have trouble understanding is why the rights acquired by the owner of stock in a cooperative and the leasehold that flows from that is not a beneficial interest in the real estate that constitutes the homestead. I'm just having trouble understanding. I mean, it's certainly some kind of interest, and it seems to be beneficial. It seems to be a benefit to them. So I don't understand how that's not considered to be a beneficial interest.
Well, sir,
Tell me what I'm missing.
Yes, sir. The common law from prior to 1776, coming from England, says that a leasehold interest is intangible personal property. Nothing has changed that as a general rule of common law. In the cooperative statute that is being presented to the governor shortly, that will change. In the condominium statute, that has always been the case. The condominium statute says in particular.
Well, but what I understand that the stock is a personal property. I understand that. But the point I'm struggling with is why that the ownership of that personal property doesn't carry with it a beneficial interest in the apartment where the homestead could be established.
The answer is, Your Honor, that as you admit, the stock is personal property. Common law says.
Well, that's not an admission. That's just undeniable fact.
Okay, it is an undeniable fact that the stock is personal property. It's an undeniable fact that the leasehold is personal property because that's what the common law says clearly. So this person has two instances of personal property as evidence of his ownership.
What about the beneficial interest in the apartment?
He doesn't have a beneficial interest in the apartment insofar as a beneficial interest in the real estate. He may very well have a beneficial interest in the corporation that owns the real estate, but you're taking it one level further.
But the whole point of all that is to get a place to live.
That is absolutely correct. And the argument is that if it walks like a duck and quacks like a duck, it must be a duck. And that's what Southern laws found. And they ignored Wartels in finding that.
Counsel, your time's almost up. Can I just ask you a question though?
Surely, I'm sorry.
We're going to link these issues though back to the text of the Constitution. When it says the following property owned by a natural person, do we essentially have to say that the property that's being referred to here is the lease? If you go down the path that the chief is asking you about.
Yeah, yes, sir, you do. You have to say that the lease and the membership stock certificate or some combination thereof is an instant real property.
Okay. Well, and if that's so, how is that just as a matter of just applying this is very arcane stuff, but the basics of how we interpret the Constitution, how is sort of the natural kind of ordinary sense of the language when you see the following property owned by a natural person, and then you get into the homestead and talk about the land and whatever, how would a reader of that understand that to be a reference to a lease and stock in a corporation?
Well, this court held in Wartels that it was not.
And so what is your understanding then? It seems like in order to even entertain that argument, you have to look at the word property as if it's being used in terms of this kind of abstract legal sense of interest, as opposed to the thing, the actual, physical thing that is owned. Is that right?
It can't be an interest in property. The term, the words used in Wartel were an interest in real property. Now that interest may be, as I say, tenants in common, fee simple interest, even beneficial interest qualifies, but it has to be an interest in real property, and a co-op is not, as the court found in Wartels.
And Chief, do you mind if I ask one more question?
Oh no, go ahead.
So one of the sort of concerns that I have about this case is that you have a precedent that is directly on point. You have a very kind of simple certified question. You have this probably new law kind of, waiting to come into existence, which it seems pretty obvious what the law is trying to do, but I'm not sure whether constitutionally it kind of gets people where it wants to be. But putting all that aside, if we sort of reopen Wartels and we start going back to the studs and kind of, defining what does property mean and what is ownership and all that. I'm curious, just are there any sort of collateral consequences in other areas of the law that you would, you're an expert in this area, that you would want us to be aware of if we were to go down that path?
Yes, sir. My co-amicus told me I would probably have that question at the outset. It's at the tail end, but yes, now any person with, if you are to rule with the petitioner in this case, any person having a leasehold interest on a property if they reside, it could be a year's lease, it could be 10 years lease, it could be 99 years lease, it could be a perpetual lease. Any of those persons now have creditor protection in that residence that they did not have before. So there are literally hundreds of thousands, if not perhaps millions, of Florida residents who reside on property with leases who are not now protected by Article 10, Section 4, who will become protected by Article 10, Section 4. This is far beyond the issue of just a co-op if you decide that in that manner.
Okay.
How often, let me ask you this, counsel, how often do creditors execute on the leasehold tenants' interest of residential tenants?
I would say very rarely, unless it happened to be a 99. Or
you think it's rare? Have you ever known of it happening?
No, it has to have a value, and a long-term lease or longer-term lease could very well have a value depending on what the rental was.
Well, long-term, yes. All right. Now we turn to rebuttal. Mr. George.
Thank you, Your Honor. I want to go back to one thing quickly on the residential cooperative. Under 719.13, it says in parts that the cooperative is not a residential cooperative if the units are used primarily for commercial units, or if the units are intended to be used as housing or maintenance, managerial, janitorial, or other operational staff of the cooperative. If a cooperative is a residential cooperative under this definition, but has units intended to be used for commercial and industrial, then the cooperative is a residential cooperative with respect to those units intended for use as a private residence. And then that brings me to the issue of the cooperative owning the property and the unit owner owning the unit. It doesn't make a difference. We can go back to Pasco, Hill, and Milton, and they tell you they tell you that you don't have to be the single owner of the property in order for you to acquire a beneficial interest that is entitled to a homestead designation. In addition, some corrections.
Just so that people know, I mean, the language that you're talking about might be relevant if we were to kind of revisit this whole thing, from the outset, but that identical language was in the law that pre-existed the 76 Act and that would have been on the books at the time of Wartell. So that's only relevant to the question of was Wartell's correctly decided in the first place. It's not relevant to the certified question.
I agree, Your Honor. I just wanted to get a clarification regarding there being units. However, with regards to Bessemer was never overruled. The Hill, so Milton was never overruled. They say that a beneficial interest is all that is needed. And this is a beneficial interest. And the question with regards to filing a lawsuit to remove a tenant. The tenant gets removed by an eviction, and Miss Townsend was not evicted. She had all
right, counsel, your time has expired. You need to sum up in about 15 seconds.
Okay. Your Honor, what we need to look at is that this overall scheme that started in 1977 with the enactment of Article 7.6 and the statutes with regards to cooperatives and condominiums was all designed as a scheme towards exactly what the legislature is doing right now with this new bill that, as I said, I believe is now law, defining this as real property. And I ask that the court find that the property interest owned was real property, that the homestead, that she was entitled to homestead. There may be proceedings necessary to solidify this, but petitioner is entitled to a homestead designation under the Constitution because this is provided to the citizens of Florida. And under the Constitution of the United States and Florida, she's entitled to equal protection over the courts.
All right. Well, we thank all three of you for your arguments today. We appreciate it. And the court will now stand in recess for about 10 minutes before we take up the third case on today's docket. take up the case of Gordon versus the state. Counsel for the appellant.
May it please the court. I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Michael Gordon. I'd like to reserve 5 minutes for rebuttal. 7 issues in the brief. If I run out of time, and I almost certainly will, rely on my initial and reply briefs. I will need to address the Houston case, which the state cited as additional authority at 3:30 p.m. on Friday. But other than that, whatever I don't get time to argue, I'll rely on the briefs. Racially discriminatory peremptory strike harms the litigant, the juror, the juror's community, and the public at large. Prevention of racially discriminatory strikes is so important that Justice Breyer would have eliminated peremptory challenges altogether. The majority of the U.S. Supreme Court was not ready to go that far, but they have made it clear in a series of decisions dating back to 2005, Miller L., Snyder, Foster, and Flowers, that pretextual reasons for the exercise of peremptory challenges will not be tolerated or swept under the rug. The entire record of voir dire must be considered under a totality of the circumstances test to determine whether the reason is genuine or pretextual. That series of decisions has made it clear that the reviewing court is not to put on blinders, not to restrict review only to evidence that was specifically cited to the trial court.
Counsel, I'm sorry to interrupt you. Could I ask you about preservation and your argument for why what counsel said here was enough under to satisfy the test set out in the 2020 Johnson decision? Because it seems like part of the rule there is that you have to, put the court on notice as to what, why you would say it's a pretext. I mean, obviously the two reasons given were both facially race neutral. And so the question becomes, are they pretextual? I don't really see anything in here where counsel, especially as to the I'm not God thing, and I understand where if you read what the juror said, I understand the argument for why the prosecutor was maybe mischaracterizing what she said or whatever. But as far as just the preservation issue and putting the trial court on notice, I'm having a hard time seeing how trial counsel satisfied what we said in Johnson was necessary.
My understanding of Johnson is that now it was not completely clear before Johnson whether 2 objections were required or 3. Johnson made it clear that it's 3, which is consistent with the Floyd decision. You need to object to the strike of the juror and identify their race, gender, or whatever the basis of that is. That at that point, the opposing party, the party that is exercising the strike has to explain their reasons. Then Johnson says you have to contest the reasons. You have to put the trial court on notice that you're contesting the reason. And then the third preservation element is that you have to renew the objection before the jury is sworn to make it clear that you still are not satisfied with the jury that was selected and you were still maintaining the constitutional basis of your strike. That was all complied with.
Here, though, isn't there, counsel, in that we don't know all of the races of the jurors relevant to determining the disproportionate impact of the proposed strike here. Isn't that correct?
That is correct, but I argued this issue on the same juror. Okay, this is juror Kimberly James. The state preemptorily struck her twice, and I argued 2 issues based on the peremptory strike of the same juror. And the reason I did that is because I didn't want the comparative analysis issue, which is constitutional, but I didn't want to bleed into the first issue, that is, even if you don't do comparative analysis, and I contend that it's required, but even if you don't do it, these reasons, just looking only at the questioning of juror James and the answer she gave and the reasons the prosecutor gave, are so clearly pretextual you don't even necessarily need to go to issue 2.
But could you tell me though, where in the record does it show that at the trial level, the court was told, this is pretextual and here's why it's pretextual?
Well, I want to get into that.
Which is that required? I mean, before we get to whether it's there, would you agree that Johnson requires that?
I would agree. It's not a simple yes or no question, even as to what Johnson requires, and here's why. Johnson says that even if there's nothing whatsoever said after the state gives their reason, or after the challenging party gives their reason, even if nothing whatsoever is said, there's like a not always footnote in Johnson, footnote 1, that says that, of course, the trial judge can do the genuineness inquiry anyway. That's what happened. In other words, the I am not God reason that was given, defense counsel said, I don't think that's a sufficient race neutral reason. Maybe that wasn't enough to comply with Johnson and Floyd, although he did contest the reason. But the fact is, Judge Harb, knowing full well that he was supposed to make a genuineness inquiry, determine whether this reason was genuine or pretext for race discrimination. He did that, and he concluded that I can't find that this reason was genuine, which was completely supported by the record. So what Judge Harb did on the I'm not God comment was exactly what this court basically said he certainly can do, maybe should do, even if there's no objection at all. So Judge Harb knew that he was supposed to make a genuineness inquiry, and he did, and he found the first reason to be not genuine. Then the second reason, the one about the cousin, the defense went a little bit further in contesting.
And I'm curious as to how you know that from the record. I mean, if we're speculating, we could say that what Judge Harb did was he was confused because of the way the issue was presented. The objection was phrased that did not ask him to make a genuineness finding. But then later, when a further objection was made and he took 8 days and he studied and researched the issue, maybe he then came to the conclusion that, oh, okay, right, the question is genuineness. And then when he rules, maybe then he said, yeah, I think this is genuine, looking at everything. I mean, that could have equally been what happened, correct, in his mind.
I don't think that's correct. On the first objection, let me find it here, what he said. On the first objection, on the I'm not God objection, he sums up by saying, the court must be satisfied that unless the articulated reason is genuine, the court should deny the peremptory challenge. Okay, so the challenge is denied as to Ms. James. That's footnote 1 in Johnson. Mm-hmm. Okay, then then the state, okay, so the state has made their objection. Judge Harb, and he probably shouldn't have done this, says, well, if anybody has any other reasons they may want me to consider. At that point, the state, it's not uncommon for the state or for the challenging party to say, I got 2 reasons, I got 4 reasons. Some of these cases that U.S. Supreme Court cases, there's 6 or 8 reasons. The prosecutor didn't say anything about the cousin, even at the point in time when Judge Harb says, anybody got any other reasons? Then the judge,
I do want to get back to Justice Muniz's question, but so if you look at this as 2 separate instances, wouldn't you agree that we had a race neutral reason and none of us were there? Judge Harb could have concluded that, I mean, if he had ruled that, if he had overruled the objection, there would be no basis for any kind of appellate relief. I mean, he could have gone either way, and on this record, we could, I mean, if he found it was genuine, if he didn't find it was genuine.
I don't agree that if he had overruled the first objection that would have been the end of it. But the fact is, the argument is much stronger that he disagreed with the reason. He found it not to be genuine on the first one, which, as Miller L says,
I mean, on the first one, couldn't the juror, we weren't in the courtroom, but the juror could have had maybe, I mean, it's what the juror said at first. It's not my job. I'm not God.
That's not
inconsistent with what the juror said right after that. I mean, juror said 2 different things.
I disagree. I think that if you look carefully at the voir dire on that, what happened was the prosecutor asks, have you thought about the death penalty? Have you had any conversations about it? Have you thought of it? The juror says, well, sometimes I'm watching TV. I'll be watching a crime story on TV and they'll talk about it, but I'm not there to look at the evidence. I'm not God. Clearly, this is not ambiguous. What she's talking about is this is not a court proceeding. She's not deciding. She's not clairvoyant. Okay, she's watching a news story. She doesn't know if it should be death or not. Immediately after that, Okay, what were your thoughts when you saw it on the news? Well, sometimes it's merited and sometimes it's not. There again, I'm not there to look like at evidence to see whether the person should die. You know, I'm not God.
Okay.
Okay, do you think you would have any difficulties voting to impose the death penalty? No, I wouldn't say that, but I would want to see the evidence. Prosecutor, I'm just asking because you used the term, I'm not God, and I understand some people have religious beliefs and they're entitled to that. Ms. James, it has nothing to do with religion. It's just how I am as a person. I want to see the evidence. If it warrants death, so be it. If it warrants life, life. Would you be more inclined to impose life in prison rather than versus the death penalty? Like I say, I'd have to look at the evidence. Okay? She says, yes, all right, it's a must. Then they go into, does she belong to any organizations that oppose the death penalty? No. Does she feel it's imposed more often against African Americans? No, I don't know the statistics. I can't say that. If tomorrow were election day and you were being asked to determine whether the death penalty should be retained in this state as an option for punishment, what would your vote be? Yes. If the state, and then, she makes it as clear as it could be that she's not talking about religion, that she's not talking about, I have a religious belief that says I can't sit in judgment on somebody. She's saying repeatedly, I am a person who wants to look at the evidence. I could go death, I could go life. I don't have no predisposition. It depends on the evidence. The I'm not God statement, which the prosecutor took completely out of context, was in regard to, what do you think when you're watching it on the news? Well, I don't know. I'm not God. I'm not clairvoyant. But she made it very clear what she would do as a juror. The prosecutor didn't even think that was a good enough reason to say when he first challenged the juror.
So if we rule on your favor on this point, though, on preservation, we're setting a precedent that when you tell a trial court, quote unquote, it's not a sufficient race neutral reason, that the courts are supposed to know that that's code for, you know, it's not race neutral and it's pretextual and it's not genuine. I mean, can you explain how that puts the court on notice as to what the problem is? Because obviously, whether something is race neutral is a separate question from whether what is said is a pretext or not genuine.
Well, again, I think that the first objection to the I'm not God, possibly that wasn't sufficient under Johnson, but Judge Harb did exactly what footnote 1 in Johnson says do. The second, at which point, this is look at the pretextual timing, as Miller L says, the reeks of afterthought reason, which the prosecutor.
But you're getting into the substance of whether it was pretextual, and I'm asking you about preservation.
I don't think the first.
Should lawyers be able to tell a trial court it's not a sufficient race neutral reason? The courts are supposed to understand that that's code for these other concepts that are really the ones that you're talking about.
I'm saying that the response to the I'm not God comment, which was that it's not a sufficient race neutral reason, that may not have been sufficient.
Thing that the trial lawyer said the second time.
What on the second one, on the reeks of afterthought reason about the cousin, the objection, which the prosecutor said very briefly and then moved on to rehash the I'm not God one. The one about the cousin, the prosecutor said, well, she had a cousin that got 25 years and we're concerned about her ability to give the state a fair shot. And the defense lawyer replied by saying, she said it was a fair sentence. A fair sentence, I think, is what she said. He contested the reason in pretty much the same terms as the prosecutor gave the reason. Now, I believe that a fair reading of the U.S. Supreme Court cases in Miller L. and Flower and Foster and Snyder makes it very clear that you don't have that you don't restrict review by basically looking at only the four corners of the reason that the trial lawyer gave. That in the Flowers case, they talk about the outcome in this case depends. They're talking about juror Carolyn Wright. The outcome depends on whether we look at the strike in isolation or whether we look at the whole picture. And our precedents require that we look at the whole picture, and they're right, because that's the precedent of Miller L. Snyder and Foster. That the U.S. Supreme Court wants a searching analysis of was this a pretextual reason for racial discrimination. They do not want a game of Stratego. And you need to look at the whole picture, both at issue one as to what was said, what Juror James actually said, which is so different from what the prosecutor cast it as. And then number two, the comparison with the other jurors. I believe it was Justice Coriel, it was a while ago, asked about, we don't know the race of the other jurors. And that's absolutely true. I mean, I know the race of the other jurors, but that's outside the record. I tried to get the court to grant my motion to reconstruct the record, and I stand by that. I asked the court to reconsider. I stand by the constitutional arguments there. And, you know, so to the extent that we don't know the race of the other jurors, that's because, you know, I would rely on the Jamerson versus Reynolds case on that. There are, on the question, the court might ask the question of whether Miller L says that comparative jury.
I think that, doesn't that take us though to a sort of a place where we're questioning our ability to substitute ourselves for the judgment of the trial court? The trial court here, on the basis of a totality of circumstances that we do not have before us, right? Like you've just sort of pointed to it, made a decision. And I guess my question is, what deference is that decision due when we have a record like this, where there were, you know, we've been talking about the I'm not God. I think a little lost in the shuffle is the sentence that she speaks right before that, where she actually says something inconclusive about her ability to read the evidence. She then changes her views. The court finds, you know, then there's a whole cousin thing. The court finds, based on the totality of the circumstances, what it finds. I guess my question is, tell me why we should supplant our judgment for the trial courts given all of those facts.
The judge has a certain amount of discretion, but it's not limited discretion. It is limited discretion, as the U.S. Supreme Court case.
Nobody is saying that it isn't. I guess my point is, you know, without creating sort of the straw man, because nobody is saying that, help me understand why this is the case where we override the trial court's decision.
Well, the first thing I got to say is I have to take issue with your statement that she changed her mind about looking at the evidence. Yes, there's a statement. The statement that she says, I'm not there to look like evidence. What were your thoughts when you saw it on the news? Well, sometimes it's merited and sometimes it's not. There again, I'm not there to look like evidence to see whether the person should die. You know, I'm not God. She's clearly in context talking about watching it on the news. And as soon as the conversation shifts to anything about the courtroom, she unequivocally, repeatedly says, I'm there to look at the evidence. She didn't change her mind. It's just a different context of how the question was asked. And I would also point out in that regard, look at the Foster case where they're talking about juror Hood. One of the reasons the prosecutor gave was based on he was a member of the Church of Christ, and the prosecutor was of the opinion that the Church of Christ has views along those lines, negative views of the death penalty. There was no showing that the particular juror Hood had those views. In this case, if the prosecutor was concerned about religion, he asked, you know, hey, some people have these religious views. And she says, that's not what I'm talking about at all. Could not have been more clear. You know, another example, if you look at the Flowers, Mississippi Supreme Court cases, one of the jurors that they talk about, Burnside, Edith Burnside, who was not the one that they reversed it on, the U.S. Supreme Court, she was an example of a juror who did in fact have those kind of, I am not, my religion tells me that I should not, I don't like to sit in judgment on people. You've seen that in Bordars. I've seen that in Bordars. That's a thing, but that is not anywhere close to what Juror James was saying here. The prosecutor twisted it, took it out of context, and that in itself is indicative of pretext, as is coming up with the second reason about the cousin after Juror James was already seated. And she said, I got a backstrike here after 8 more jurors, or I think it was 9 more jurors are discussed. Well, number one, it's not a backstrike, and the state seems to want to characterize my argument as being that I'm complaining about an improper backstrike. No, that's not what I'm doing. If that had been preserved, maybe I argue that as a backup issue 3, but that's not what I'm arguing. What I'm arguing is, as in Miller L., that pretextual timing of this is an indication of what the prosecutor was doing. Now, again, am I saying the prosecutor was a racist? I have no basis to say that. I mean, I'm sure that there, in today's America, there are racist lawyers, prosecutors, defense lawyers, civil litigators, but that's not what Batson is about. Batson is about, was this strike exercised against this juror for racial reasons? This is a case where we've got a black defendant, 2 innocent white victims. If the prosecutor was thinking, I just don't want too many blacks on this jury, doesn't have to be Charlottesville, doesn't have to be Ku Klux Klan. I just don't think it would be good for my case to have too many blacks on the jury. So maybe I'll let one sit, and then use peremptories on others. Look at Sanchez versus Roden on that. It's one juror, one racially motivated strike is one too many, constitutionally one too many. So again, I mean, our position is that the direction of the U.S. Supreme Court is that a reviewing court on a Batson issue is not to put on blinders, not to limit its review based on, I mean, the lawyers, did they preserve this perfectly? Probably not. Did they object 3 times as Floyd and Johnson required? Yes, they did.
Mr. Bulletin, just as a matter of broader policy, say that we all agree that Batson's correct and that the right and interest that's being protected there is a critical one, an important one. But we also recognize that it's not one that it's not your client's right. So your client, there's no argument in this case that your client had a properly seated, fair and impartial jury. And we're talking about jury selection issues, but at the end of the day, your client had a fair jury, an impartial jury. And so why isn't it appropriate in this context where your client's asking the state of Florida to expend extraordinary resources to retry him, the citizens of the state, extraordinary resources to retry him based on a claimed error that didn't affect his trial or the fairness of his trial? Why isn't it especially appropriate in that context to have preservation requirements that make sure that your client's attorney is going to get this issue in front of the judge in a way that assures that the judge clearly understands the arguments that are being made and that will be made on appeal? I mean, isn't that appropriate in this context?
I actually think that the fact that Batson is designed not only to protect the litigant's interests, but also to protect the juror's interest, the juror's community's interest, and the public interest is all the more reason not to have draconian waiver requirements, because you have to have deterrence. And
why is it draconian to put the trial judge on notice of arguments that you have in support of your position so that the trial judge has all the information necessary to make the best decision possible before you try to get the case reversed? Why is that?
Well, Judge Harb said that, I'm looking at my notes to see what I have in addition to what was presented by the state and the defense. I think that, I cited a case where a Texas appellate court judge in a concurrence said Miller L. is, commentators have described Miller L. as the case that put teeth in Batson, okay? If you put requirements that essentially require...
Sorry, I didn't understand you. It said it what? Miller L. what?
Put teeth in Batson.
Teeth, okay.
Miller L. has put teeth in Batson. And the court has been very vigilant to make sure that Batson doesn't become toothless, which would if you basically require the trial judge to make the appellate argument, the trial lawyer to make the appellate argument during the heat of voir dire. I'll give you an analogy. There are lots of appellate issues that are reviewed under totality of the circumstances. Probable cause for arrest or search. Was a person in custody for Miranda purposes? Was a confession voluntary or not? Was a pretrial ID overly suggestive? Was the in-court ID reliable enough to come in anyway? All of those deal with totality. For example, on ID, you've got the Wade factors and the Stovall factors. You've got a non-exclusive list of 5 or 6 factors that are to be looked at to make that determination. When an appellate court is reviewing that under the totality of the circumstances, they don't say we're only going to look at one of these Stovall factors because it's the only one that the defense lawyer specifically argued. The evidence, the facts of the voir dire, those are not grounds for the objection. The grounds for the objection is this is a pretextual racially discriminatory strike. And I think that a fair reading of the 4 U.S. Supreme Court cases and some cases mentioned in my brief that discuss those cases is that the appellate court is supposed to review the entire record and is not supposed to limit itself only to what was specifically pointed out below. I would point out that that is Justice Thomas, who dissented in all 4 cases. And the cases were, I think, 6-3, 7-2, 7-2, and 6-1-1. They weren't even all that close, but Justice Thomas is the consistent dissenter. The state tried to rely on Justice Thomas's view. Justice Thomas makes the same point that the court is concerned about, well, this was not specifically pointed out to the judge. The majority goes the opposite way. The state of California.
Counsel, you are now well into your rebuttal time. You can keep going, but you just need to know you're into it.
Okay, I need to, I'm afraid I'm going to use up my rebuttal time. I will rely on my briefs, which cover all this, including California, Texas, 4th Circuit, 9th Circuit, 6th Circuit. But I do need to address the case that the state cited an hour and a half before the end of the last working day before the argument, which was the Houston case. The Houston case was a 2006 case. Number one, Houston case says that the reasons given by the prosecutor were forthright and non-evasive. That's very different from here. The Houston case tries to distinguish Miller L by saying, now Houston came out a year after Miller L, tries to distinguish Miller L by saying Miller L was an old case that was tried under Swain, and they had a post-trial Batson hearing. So that's very different. We don't think Miller L applies. So we think that the trial lawyer has to point out the race of the jurors thing. But the thing is that Houston does not take into consideration then Snyder, Foster, and Flowers, all of which were tried under Batson. The case of Kessler versus Canberra, which I will cite as additional authority today, says that situation provides an even better basis to do comparative analysis without it having been raised below. And then finally, footnote 9, I believe it is, in the state's Houston case, actually gets backwards what the Miller L court said in footnote 2 about the difference between evidence and theories about the evidence. It gets it completely 180 degrees backwards. In fact, what Miller L is saying is that the evidence that is in the evidence that's in the trial court record, the evidence of voir dire, is what the appellate court is supposed to consider. And I probably have used up all my time, but so be it. Thank you.
Well, counsel, you actually have 2 minutes remaining.
Well, I'll take it.
Okay. All right.
Sorry, I'll save 2 minutes for rebuttal. Thank you.
Good. All right. Counsel?
Thank you, Mr. Chief Justice. May it please the court. I'm Assistant Attorney General Rick Buckwalter, and I represent the respondent in this case, the state of Florida. As the courts noted, in this particular case, the Gordon never preserved the arguments he now desires to make before this court by raising them with the trial court at the time the issue arose. Excuse me. He raises numerous arguments at this point. None of them were raised below the trial court when there was an opportunity for the trial court to go ahead and examine that issue. And this court has consistently held that the arguments are waived if not raised at the time. Specifically, the only two arguments that are actually ever raised on this issue was raised through defense counsel stating that he did not believe that the explanation provided by the state was race neutral. The second time when the state backstruck the juror successfully. Again, he raised the same exact argument that he did not believe that the explanation being provided by the state was race neutral. He did add an additional comment at that point in which he said that he thought, or he stated that the juror thought that the sentence provided to her cousin, which was 25 years in prison, was a fair sentence. However, given this court's previous decisions on this particular type of issue, those are the two arguments the defendants limited to on appeal, given those were the only ones that were raised and preserved. Any other arguments he raises today are waived. This court stated that in order to reverse the decision of the trial court on this issue, they have to show that the trial court was clearly erroneous. And based on the arguments that have been raised, first, that the basis given was not race neutral, and the explanation or the further statement that the juror thought that the sentence was fair would be the two arguments that can be raised, and neither one demonstrates any basis for finding that this trial court was clearly erroneous in allowing the strike. The defendant argues that, I'll strike that. The defense argues that Miller L requires this court to go ahead and perform a comparative analysis as well. However, there's nowhere in the holding or in the decision itself that the Supreme Court ever states that the appellate court is required to go ahead and do a comparative analysis if that's not raised before the court at the trial level.
Counsel, I'm sorry to interrupt you. And I think you have a strong argument on preservation, but if we don't agree with you on the preservation thing, and we look at what this juror said, you know, in a lot of these cases with jurors, the jurors give sort of a meandering answer, and they say some things that are problematic and other things that maybe fix the problem, and then the fight is over which part are you going to kind of emphasize. In this case, this juror seems, if you look at sort of the two areas that were raised, you know, the I'm not God thing and the, you know, cousin with the criminal episode, this juror said she's almost like a model juror in terms of giving a coherent answer that would communicate the idea that they can, you know, fairly and impartially look at the evidence. And so, again, if you get beyond preservation, can you point to something in her answers that would, you know, that would support the idea that would kind of back up sort of the prosecutor relying on those two things? Because it's hard reading the answers in their totality to find any fault with what she said.
Well, I think the mere statement that she makes, that she says she's not God, in a murder case in which she may be sitting in sentence in determining whether or not to sentence this.
Well, counsel, isn't it just overwhelmingly clear that when she said that, she was talking about what she saw on TV, not what she was doing in court? The context of that is entirely different, and it's more like it seems like the only reasonable way to understand that is that she's saying, you know, I don't know what happened. I'm not omniscient. I'm just seeing this on TV. Who knows? Isn't that the most reasonable way to understand that?
Well, that's clearly the defense's position. We don't see it that way. At the time, she's asked by the prosecutor whether she's ever seen the discussion on TV, what she thinks about when she sees the discussion on TV. And her response is, I'm not God. I don't think there's any prosecutor's head who wouldn't snap around upon hearing that, given the question that was asked and the fact that this is a murder case. And so I don't think that it's unreasonable at all for a prosecutor to be concerned upon hearing that and to go ahead and move to strike the juror. Taken into consideration.
Going back to, it was already read by the defense, but I think I'm struggling in the same manner that Justice Kennedy is, Chief Justice Kennedy. Do you remember the last time that you thought about the death penalty? The prosecutor asked. Well, maybe like watching the news or something, being on a crime or something like that. Other than that, no, it's not like an everyday thought. And then the question is, what was your thought when you saw it on the news? And the answer was, well, sometimes it's merited, sometimes it's not. I'm not there to look at the evidence and see whether the person should die. I'm not God. I don't see how you really fairly read that any other way than in response to the question, what were your thoughts when you saw it on the news? That was the question that was asked.
That's the question that's asked, Your Honor. I think that is not, it's ambiguous to the extent that she's asked, what are your thoughts when you see it on the news? The question is not asked, do you know whether, what the facts are? And then her response is, I'm not God. The question is, what do you think when, because she doesn't normally think about it.
Even if it was ambiguous, there were follow-up questions. So even if you're right that it was ambiguous, all the follow-up, it's clear that she, as Justice Muniz said, is a model juror in her answers. She was going to decide this based on the evidence, and there's no religious concern that would prevent her from doing that.
Well, with all due respect, the way I interpret that response is that she has concerns about her ability to sit in judgment on an individual in a murder case. Her statement that she's not God. In addition to that, there's the second basis for the strike, which is her cousin's conviction in which he was sentenced for 25 years. And the trial judge, in ruling on the case, ruling on the objection, stated that he was taking into consideration the totality of the circumstances, but particularly the second basis or the second explanation provided by the state, which suggests that the court's taking into consideration both the reasons provided by the state, and the state did reassert that reason the second time around.
But the second reason, counsel, is even more implausible than the first one. She said everything that anyone could possibly say to communicate the idea that she's trying to be forthright and answer the question and maybe even go above and beyond by even bringing it up, but that it's not going to have any effect on her. This juror, we read stuff all the time where the lawyers are trying to confuse the jurors into saying stuff that's a problem, and then everybody's trying to rehabilitate people. This juror said everything that we want people to, be able to articulately communicate in these situations.
And although the court may feel that the decision made by the prosecutor may not have been a wise one, I suppose would be the term I would use to describe what the court seems to be concerned about. The issue isn't whether it was a good decision, a smart decision, but whether or not there was racial discrimination in making that strike. And in this particular case, there just isn't the arguments that should have been raised, or which the defense now wishes to raise, weren't at the time raised.
Counsel, on the issue about I'm not God, doesn't your argument kind of boil down to the fact that in a death case, if a juror in any context utters that phrase, that's kind of like waving a red flag at the prosecutor. And it may not even be the most reasonable reaction of the prosecutor, but it's a genuine concern that the prosecutor has whenever they hear that kind of phrase in the context of a death penalty case.
That's exactly right. And that's why I said I don't think any prosecutor's head wouldn't snap around upon hearing that phrase, because that's clearly a real concern. So regardless of anything else she may have stated, the prosecutor heard those words and responded to those words. And I don't think we can sit here and say that that's not a reasonable response by the prosecutor. It certainly doesn't show any indication that the prosecutor is acting in a discriminatory manner. We also should consider the fact that not only did she make that statement, but she's the only juror who both has an issue with regard to the conviction and the sentence on her cousin, as well as having made that kind of comment. So I think that when we take a look at the totality of the circumstances here, the way any prosecutor would take a look at it is that they would show concern and they would move to strike the juror. And that's what happened in this case. And even after the court initially finds there's not sufficient basis for the strike, the state comes back and reasserts that again the second time around, noting that, yes, Your Honor, you've already ruled on this, but you really need to consider this. I mean, it's clearly something the state was reasonably concerned about. As far as the Gordon's argument that Miller-El requires this court to go ahead and perform a comparative analysis, I think we have to bear in mind that in this particular case, we have a procedural, a procedural bar to the review based on the failure of the defendant to go ahead and raise the issue. But that wasn't the issue in, actually not the issue, that wasn't the case in Miller-El. There were no procedural bars to the Supreme Court doing the comparative analysis. And in fact, in Louisiana versus, in the Louisiana case raised by Gordon, there's actually a footnote 2 in that case, where the Supreme Court notes that there was no procedural bar raised in that case. And that in fact, the state Supreme Court actually went ahead and did one, even though that wasn't raised at the lower level. So I think those cases are distinguishable from this case because there were no procedural bars to a comparative analysis as there is here. And of course, there's good reason for this court to have determined previously that the defendant should be required to raise that issue at the trial court level, because at that point is the only point where during the trial, when the problem occurs, that the problem can be corrected. The court gets placed on notice, the court can inquire further, the state can provide explanations, and none of that occurs. Instead, here we are several years later after defense has had an opportunity to spend several weeks at the minimum going through the record and mining for different issues in order to raise, which doesn't happen at the trial court level. It's the defense's obligation to go ahead and inform the court and make the objection and make the proper arguments that would allow the court to rule in its favor. And that wasn't done here. So what we're left with is the 2 objections that were raised, that it wasn't race neutral, and that that it wasn't race neutral, and that she felt it was a reasonable sentence or a fair sentence. And in this case, the standard for reversing the trial court is showing an abuse of discretion by the trial court, having made a clearly erroneous decision. I don't think that we can say that that's the situation here, that the defense has gone ahead and done that. If there are any further questions from the floor.
I actually have a question on one of the issues that wasn't addressed in the initial argument, but it's in the brief. Issue 7, the attempted first-degree murder of the 2 deputies, and these are related to the defendant's escape from the home in which the murder victims lived as he crashed through the garage door and then tried to get away, driving fast down the road. Could you tell me what the relationship of those, where those 2 deputies were, what the record shows about where those 2 deputies were in relationship to the car, and what the record shows about what the defendant would have known about their relationship to the car as he was driving?
Yes. First of all, with regard to one of the officers, the record states, is at the end of the driveway, and that he trips and falls in the road. The other deputies in the yard, it's less clear from the record precisely where that deputy is, but he's apparently somewhere in the front yard, a few feet from the driveway. That's what the record seems to reflect. As the defendant comes bursting through the garage, one of the deputy tries to get out of the way. He tries to run out of the way, and he says that the car actually comes in his direction, turns in his direction at that time. The deputy who is at the end of the driveway had fallen down and said the car was coming directly at him. That's when he shot his shotgun, and the car turns away.
How far away when he fell? How far? What's the closest that the car came to him, according to the record?
Said the car. He estimates the car came within 10 feet of him, I believe it is, and that's when he shot his shotgun. In other words, it's coming directly at him 10 feet away. In other words, not 10 feet to the side, because he's at the end of the driveway. But it's coming at him.
But the car had to go, but the car got through the end of the driveway, right? I mean, because the car got out onto the street.
Because it turns after it's shot at. The number of the officers basically unload their weapons on the car.
Well, I'm sure. I'm sure there's a lot.
Turns, and so it doesn't.
I'm just trying to understand how this is anything other than the defendant trying to get away from here, and then not. It's like I'm trying to see what shows that he was aiming at the officers with the car, other than just going down the driveway. And is it even clear in the record whether he was backing out or going out front ways?
The different witnesses have different perceptions. At least 2 of the officers state that the car came out backwards. Other witnesses indicate that that's not the case. However, the issue here would be that the one officer actually moved as well, and says that the car steers towards him. However, even if this court were to find that there's insufficient evidence of attempted first-degree murder, there should be sufficient evidence. There's clearly sufficient evidence of a attempted second-degree murder. That was one of the lesser includeds that was read to the jury. They were instructed upon. I also think it's important to point out at this point that although the attempted murder of these 2 officers were used as a basis for showing an aggravator in the sentencing, there were a collection of different bases for the prior violent felony or murder aggravator. There were, of course, the contemporaneous murders of both victims, as well as the 3 attempted first-degree murders of law enforcement officers at the time of the chase, and the armed robbery, as well as the armed robbery of the pawn shop, I should be specific, as well as the burglary with assault or battery against the victims, as well as the 3 prior crimes that occurred prior to this instance, where the defendant was charged with an aggravated battery with a firearm while he was in prison, he was charged with an aggravated battery of stabbing someone in the chest with a sharpened toothbrush. And then finally, several months after his release from prison, but several months before this, there were the domestic violence cases involving the strangulation of his girlfriend. So even if the court were to find that there's not sufficient evidence of attempted first-degree murder, there is sufficient evidence of attempted second-degree murder and clearly sufficient aggravators to uphold the death sentence. In addition to the violent felonies, there's the HAC aggravator involving the stabbing deaths of both these women, and as well as that this occurred in the course of his attempt to escape from the case. Unless there are any further questions from the court, I would respectfully request that this honorable court affirm the judgment and sentence of the trial court. Thank you very much.
Thank you. We'll now hear a rebuttal argument.
I spent too much of my time initially on the I am not God comment and not enough time on the cousin rationale, which was the basis for Judge Harb's allowing the second bite at the apple peremptory challenge. As Justice Muniz pointed out, the second reason is even more implausible than the first. And what makes it, even apart from the comparative analysis with jurors Kelly and Stanley, the reason the prosecutor gave when she gave her reeks of afterthought reason is absolutely inconsistent with her prefatory statement to all the jurors as to why she was asking the question in the first place. She said to the jurors, I'm only concerned if it's somebody very close to you where it impacted your life. You thought about it, you were involved in the case, things like that, like a mother, son, daughter, like that. Okay, she was in the third row initially. She works her way down to the second row. Juror James has her hand up because she's conscientious and excess of caution. And the first words out of her mouth is, it didn't affect me, it was a cousin, first cousin. And then they go into it and all the questioning shows that she completely was somebody that the prosecutor basically just said, I'm not concerned about this. I had nothing to do, I wasn't in court, it didn't affect me. I thought that the trial was fair, the sentence was fair. She didn't even know exactly what sentence he got. She said, I think it was like 25 years. The reason the prosecutor gave when given an improper second bite at the apple was absolutely inconsistent with the prosecutor's own reason for asking the question in the first place. She didn't even ask Juror James, were you close with your cousin? She asked Juror Kelly, was he close with her nephew, with his nephew? She asked Juror Stanley, who came up in the second group of jurors after James was already gone. Juror Stanley, it was a brother who had been in and out of jail all the time for drug-related offenses, which is a whole lot more related to this case, certainly in the penalty phase, than anything that had to do with Juror James's cousin. So I think that the reason it's so clear on the record was absolutely pretextual, and the only result that will prevent this from going on over and over and over again is reversal. I will point out also, if I have time, I'll go through.
I'll give you another minute.
Okay, thank you. The thing about all the case law going back to Slappy and case law from the U.S. Supreme Court, other states, other circuits, whatever, that comparison of let's say it's a black juror, comparison with white jurors who the state allowed to serve. Well, in Florida, we don't know who the state allowed to serve because of backstrikes, because of proper backstrikes. We don't know who the state allowed to serve until just before the jury is selected. By the time they even got to questioning Juror Stanley, Juror James was gone. I would cite, in terms of what Miller L. and its progeny require, look at Texas, look at California, look at the Ninth Circuit, look at the Fourth Circuit, look at the Sixth Circuit. Some federal courts have say that when the state court doesn't do comparative analysis, we'll do it ourselves. Well, we could be talking, 5, 6, 8 years down the road. Memories fade. The time to do it is now. I don't think this court even needs to get to comparative juror analysis to reverse this case, but I ask that the court reconsider my motion to reconstruct the record. I ask the court reverse Michael Gordon's convictions and death sentence. Thank you.
We thank you both for your arguments in this case today, and the court will now prepare to take up the fourth and final case on today's docket. Proceed to hear argument in the case of Levy versus Levy. Counsel for the petitioners recognized.
Good morning, and may it please the court. My name is Evan Abramowitz, and I represent the petitioner in this matter, Samuel Solomon Levy. It is well settled and well established that Florida statute section 57.105, subsection 7, extends unilateral prevailing party attorney's fee clauses and makes them bilateral. In this case, the attorney's fee clause is a bilateral defaulting party attorney's fees clause. It's therefore our position that the decision of the Third District Court of Appeal, finding that 57.105 subsection 7 applies to this case, should be quashed. This case stems from a dissolution of marriage proceeding, and the attorney's fee clause in question is contained in a property settlement agreement as well as a child custody agreement. There's two agreements here, but the clauses are identical in each of the agreements in this case. Of critical importance is that the attorney's fees clause in this case allows, quote, either party to take legal action against the other, and only the party that is found to be in, quote, violation may have attorney's fees awarded against them in such an instance. This
Counsel, I'm going to just interrupt you kind of with a hypothetical to start off. Just what every attorney likes to hear, correct? So in this type of case, I do completely understand your argument, and you're essentially saying, you know, that the party is a particular entity. And when the contract gives a particular entity, such as the lender or the credit card company, the right to attorney's fees, then 57.105 subsection 7 kicks in and makes that bilateral. And I think the case law, you know, many of the cases we have deals with that exact type of provision where it says lender, it defines a particular party. But what would prevent, if we think that your interpretation is correct and we say in this type of case it doesn't act to make that clause go into effect, what would prevent a mortgage company from changing the language of their contract to match this, to make a mortgage company, you know, if in the event either party should take legal action against the other by the failure to abide by this agreement, the violating party shall pay to the other party those expenses. I mean, clearly it's usually the mortgage company bringing the claim. It's very rarely the other side. I mean, what what prevents that from happening, which seems to go again against what 57105 is supposed to do. So how would this not just be used in those kind of situations?
Yes, Your Honor, and I understand the question, but I think it's about the type of contracts that we're dealing with in these cases, because I can't imagine, at least as I sit here, a situation where a consumer and these types of contracts that we're talking about with banks or big corporate entities would have any cause of action against the bank or the corporate entity. It's almost always the bank that is somehow suing the consumer under that clause. So I would think that if it appeared in a contract of that nature, that the ruling from this court would not apply in that situation if the ruling of this court were to agree with our position. This is reserved, and this is the argument that we make, for bilateral contracts where either party can sue the other, but there's actually a means by which either party can sue the other. So in a family law setting like we have here, a dissolution of marriage setting, there's many different issues that are addressed in a contract or in a marital settlement agreement. We have property distribution. We have custody of children. We have support. So both parties have issues they could potentially sue the other upon if there's not performance under the contract. And because both of them have the ability to do that, the contract is bilateral. I would think, to answer your question, that if a contract with a big consumer, with a big corporation and a consumer were to say language like this contract, either party, that the decision here still would not apply because they wouldn't have the ability to actually avail themselves of it. So maybe a qualifier is that it needs to say both parties and the actual ability to avail themselves of actually filing an action against the other party, which certainly both parties in this case can do. But I believe most likely in the hypothetical that Your Honor is discussing, the consumer would not do, because there would be no cause of action that the consumer could likely take against the big bank or the big corporate entity.
Well, that seems to assume a lot. I mean, there are some cases against banks that actually win. So
I understand that, Your Honor. But this does speak, and we point this out in the brief, somewhat to the uniqueness of family law causes of action and dissolution of marriage causes of action.
I understand your arguments on the merits, and they seem to me at least make a lot of sense. It seems to assume that 57105 applies in the first instance, and here we have an actual contract that was made in Virginia court. Choice of law principles, I guess, were not an issue in here, and we're just kind of assuming 57105 applies by both parties, right?
That's correct. So the choice of law issue was never raised before the lower court or on appeal with the third district, so it's therefore not addressed. And the assumption is that 57105 would apply if the contractual provisions called for its application, which of course we're arguing that it doesn't. And going back to the family law causes of action, I point this out in the brief. Unlike these big consumer contracts that the hypothetical that Justice Grosshans referenced, we have here people with equal bargaining power on equal footing that enter into these agreements. There is a great deal of negotiation that goes into these agreements, a great deal of contemplation, and they agree to these exact provisions for a reason. And there's a bunch of case law, including cases from this court like Hahamovich, which says that we're supposed to look at the clear and unambiguous language of the contracts. And in this contract and in other contracts that has this defaulting party type provision, it clearly says that you can only collect attorney's fees against somebody if they violate. And although it's understandable that 57105 subsection 7 takes the very big step of actually rewriting contracts in this state to protect the consumer, when it starts to rewrite contracts like this in a family law cause of action between two similarly situated parties, it is going way too far. And it is rewriting potentially thousands or hundreds of thousands of contracts across the state in situations like this in family law cases. Family law is also unique in that it has a statute like 61.16 Florida statutes, which actually allows for the award of attorney's fees if there are financial inequities between the parties. So there is other means by which to obtain attorney's fees aside from just a clause like this. And in fact, in this particular case, in the lower court, the judge reserved jurisdiction to do so. But it is inappropriate and too far for 57105 to go as far as rewriting.
Mr. Abramovich, do you essentially see this as a statutory interpretation issue?
I think it's both a statutory interpretation issue and a contractual clause interpretation issue, Your Honor.
And a what issue?
And an interpretation of the clause in the contract.
When it comes to the statutory interpretation issue, is there any basis in 57105 to distinguish between types of contracts like you're asking us to do?
There is not a specific delineation in the statute, Your Honor. However, cases from this court and a long line of cases, including recent cases like Ham versus Portfolio Recovery Associates and Page versus Deutsche Bank, have defined 57105 to subsection 7 to only apply to unilateral attorney's fee contracts, attorney's fee clauses. So because the clause that we have here is bilateral, 57105 subsection 7 does not apply. So although it doesn't make that distinction in the statute, and it doesn't say, well, this doesn't apply to family law cases,
Well, counsel, I don't want to make your argument for you, but it doesn't, when it says a provision allowing attorney's fees to a party, couldn't that reasonably be understood in context as saying to one party?
Yes.
And then it refers later to the other party. And so I think that's when the courts have used that terminology about a unilateral provision, they might have been understanding, and again, I'm not sure if this is explicit anywhere, but I think they might have been based on an understanding of what the phrase to a party means. Am I missing something there?
No, Your Honor, I absolutely agree with that. The statute clearly says a party, which is an identifier of one party. And we're supposed to read the statute as it reads and be very concerned with the way it's exactly constructed. And that's how it's constructed. When you compare that to the provision, attorney's fee clause, the provision in this case, and the Fourth DCA case, which is in conflict, which is Sackett versus Sackett, both provisions say either party. That is in stark contrast to the a party that's referenced in the statute. And that's why we have the difference between the statute referencing unilateral attorney's fee provisions and the clauses here being bilateral in nature. So yes, I completely agree with that.
Counsel, there are two cases out of the fifth that, while they didn't particularly analyze this question, they seem to reach kind of the opposite conclusion on this. And I'm not sure I'm pronouncing it right, so I'm going to take a guess. Setsinus and Cal Atlantic, where you had kind of these associations and owners, and either party could bring the fee, but they essentially, said that 57105 subsection 7 would apply. How would you distinguish those cases?
So, I understand Your Honor's question. Those cases are interesting. Both of those cases state that they are unilateral fee provisions, okay? I think in looking at the actual provisions, especially like the one in Cal Atlantic, the provisions themselves are somewhat convoluted and confusing if you read them. They involve multiple parties going back and forth, and it is a little difficult to understand the intent of those provisions to begin with. So I think in part, the decisions that we see in those cases are because of maybe unclear contractual provisions. That's what I gleaned from it. But certainly, both cases make the statement that these are unilateral provisions. And if they are unilateral provisions, 57105.7 applies. So it makes sense from that perspective, but I do think that the provisions are convoluted. And sort of to highlight that point, Cal Atlantic actually refers to the case of GEMB lending, which is a case out of the Southern District of Florida, and says that the provision in Cal Atlantic is very similar to the provision in GEMB lending. And the provision in GEMB lending is clearly a unilateral provision. And Cal Atlantic aligns its case with GEMB. If you look at GEMB, it says, the contractual provision says, if you default, you agree to pay our costs for collecting amounts owing, including court costs and reasonable attorney's fees. It's the ultimate unilateral provision. So the fact that Cal Atlantic relies on GEMB, regardless of the convolution of maybe of the provision in Cal Atlantic, it's clear that it's focused on a unilateral provision. And that's why in those cases, they say 57-1057 applies. And I think, and I understand Justice Lawson's question as to why that family law cases are not carved out in the statute. And that's absolutely correct. They're not. But if the court were to uphold the decision of the Third District Court of Appeal in this case, there would be wide sweeping impact for contracts in family law cases and other contracts that have defaulting party provisions. And it could really result in an equitable result for many citizens of the state of Florida. For instance, we could have a situation where you have a mother with 3 children who does not have financial means, who has a provision like this one in her marital settlement agreement, and she seeks some sort of enforcement against her former husband. For whatever reason, technical or otherwise, she is not successful. If we uphold the Third District Court of Appeals decision, we've put that particular individual in a place where now she can have attorney's fees awarded against her because she sought enforcement and lost for whatever reason. That is not an equitable result when that particular individual agreed to a defaulting bilateral provision in the first place and did not agree to a prevailing party provision. She should be able to contract with the opposing side and be able to rely upon the clear meaning of that contract with no concern that a Florida statute is going to rewrite that contract. So all that being said, Your Honors, if there's no further questions at this time, I will defer the rest of my time for rebuttal.
All right. Counsel?
Good morning, Chief Justice, Justices, may it please the court. This is Robert Coleman on behalf of the respondent, former wife, Eunice Bach-Levy. There was a question that was asked by Justice Grosjean at the very beginning, which is why would a party not be able to ride around the 57.1057 fees provision if it required a named party to in order to kick in? And that question was answered, or that in Cal Atlantic, the case that we had just cited, which when I'm going to quote here, it says, limiting a party's entitlement to attorney's fees on the outcome of a dispute rather than the cause of action asserted in the pleadings is contrary to the purpose of section 57.1057. To hold otherwise would enable a drafting party to construct attorney's fees provisions around the ambit of section 57.1057, resulting in an uneven playing field and thereby defeating the protection afforded by the statute. The issue here before this court is what event triggers 57.1057 as to allow fees to a prevailing defendant, and what makes a prevailing party fees provision unilateral. In the Cal Atlantic case, which is an express and direct conflict with the Sackett case, in addition to the Levy case that we're here before, that provision actually allowed numerous parties to bring a claim and would awarded them a prevailing party attorney's fees and costs had they prevailed. It was not just the association, it was any person who owned real estate in that subdivision was allowed to bring an action. And they could bring that action against any other unit or real estate owner in that. So there is no named individual that had to be the plaintiff in that case. So that sort of gets around the idea that there has to be a named plaintiff in order for this statute to kick in. And if it was required that there was to be a named plaintiff, that would be in the text of the statute itself. The legislature had the opportunity to say that there had to be a named plaintiff. It did not do so. The legislature also had the opportunity to say that this statute does not apply in family law cases, and it did not do so. This court has made it very clear in the recent decision of Page versus Deutsche Bank that this statute is unambiguous. In the Page case, this court quashed an en banc decision from the 4th District Court of Appeal, which added to the statute words that were not in the statute itself.
So what do you make of the simple sort of textual construction in the statute between a party on the one hand and to the other later in the sentence? That is to say, given that it defines a party and the other, how can we read that in any way other than the way proposed by your opponent in this case, which is to say that the legislature didn't need to make subject matter restrictions, didn't need to do anything else. Those words mean unilateral. Those words mean that you have a specific party on one hand and the other one on the other.
Your Honor, I think the answer to that question is because further on in statute, it says, quote, whether as plaintiff or defendant, end quote. And in this particular case, you have a situation where the prevailing party fees provision applied only to the individual who brought the action and then prevailed in the action. If you then say that that is a bilateral prevailing party fees provision and 57.1057 does not kick in, then in that case, there is no circumstance under which a defending party would ever be entitled to prevailing party attorney's fees and costs under the statute. That reading would literally eviscerate the defendant language in the statute itself. And statutory construction says that you are supposed to give full faith. You are to use every single word of the statute and give it effect in that statute. So I believe that's the answer to your question, Justice. And in this particular case, there is no question that the former husband had prevailed.
Let me push back on that. I'm not sure that it does, because that reference to whether as plaintiff or defendant speaks, doesn't it, to whether the party is required to take any action to enforce the contract, whether as plaintiff or defendant. Isn't that correct?
Well, I'm a little bit at loss there, Your Honor, because if the party was required to take an action to enforce the contract, that would be as a plaintiff. It might be a cross claim.
Exactly. There are ways a defendant can take an action to enforce a contract. I guess I'm not sure I agree with the argument that inclusion of plaintiff or defendant is eviscerated by the proposed reading that we have before us. I'm not sure I agree.
Well, Your Honor, the only thing I can say is that if you are going to take an action, any sort of action to recover under a contract, you are in fact prosecuting that action in order to show there's been a violation of the contract. And whether that is as a cross claim, as a counterclaim, whatever it is, you are still taking an affirmative action. And therefore, you are still in that context being the plaintiff. This is really what we're talking about here is a defensive posture only, where we are saying that the former wife who was accused of breaching this agreement, after an 8-day trial, it was shown she did not breach the agreement. And we're saying that because she was in a defensive posture, because she was a defendant, and because she prevailed, 57.1057 allows her to receive the prevailing party attorney's fees and costs. And the question that is raised by the former husband in this case is that there has to be a condition precedent to the award of fees, which again is that an individual party has to have raised the issue of breach of the contract and then shown that there was a breach of the contract. But that's not what the statute says. The statute says that it kicks in when either party, when he or she is required to take any action to enforce the contract. It's not a finding of violation of the contract that triggers the statute. It's actually when he or she is required to take any action. And then also it talks about action singular. It doesn't talk about actions plural. The former husband has made the argument that it's reciprocal because at some future hypothetical date, the former wife could file an action as well, and that she could, if she proves that there was a violation of the agreement by the former husband, that she could get attorney's fees and costs subsequent action. That's not what the statute says. What the statute says that in any action, singular, not plural, singular, that there's always going to be a right of prevailing party fees to the party that wins. In this case, the former husband, had he won, would have been entitled to fees. The former wife won. Under the language of this particular fee agreement, prevailing party fees provision, she was not entitled to fees. That's what makes it unilateral. That's why the statute applies, because if it didn't apply, we would be in a position where the former husband could at any time bring this action, cause the former wife to incur these fees, and therefore would not be entitled to the protections of the statute. Yes, Ron. The thing that they talk about, the public policy, this was not an arm's length transaction between equals. This was a Virginia agreement. If you look at that Virginia agreement, the wife was representing herself pro se at that particular point in time. She didn't have the protections of 6116 to level the playing field. It was the former husband who had counsel. It was the former husband's counsel who drafted the agreement. Now, there is statutory construction that says that any agreement is determined to be a jointly drafted by the parties, but let's be real here. There is a big difference between a party that has the ability to pay for an attorney to review two agreements of some 30-some pages long and a pro se litigant for whom English is a second language. So I don't think that the public policy argument is very strong in this case, and also it is against the text of the statute itself. If the legislature wanted to make an exception for this type of case, it would have done so. It did not. And also, the prevailing party fees provision in this case is very clearly in line with this court's decision in the Ham case and in the Page case, which were both decided in December of 2020. It is in line with the Cal Atlantic decision, which I think is very well thought out. It is also in line with the GMB lending case, which is a Southern District case that was cited by my opposing counsel. And all of those cases, there was very specific, and even in the GMB lending case, talked about a defaulting party. The GMB lending case, the court there said very clearly that it is not requirement that one party prevail in order to invoke 57105. The GMB lending need not have defaulted on anything to trigger the statute and fee provision. Your Honor, it is respectfully submitted that this court affirm the decision in Levy versus Levy and quash the decision in Sackett v. Sackett, and I will yield my time if there's no other questions.
I do have one other question. This may have been in there and I just missed it, but would 6116, the need and ability to pay attorney's fees provision, have applied to this action? Yes, it would have, had there not been a provision in the contract that provided for prevailing party fees. The Laskazani case specifically says that 6116 does not apply if you have a attorney's fees provision in your marital settlement agreement. So had that not been in there, then 6116 would apply. However, in this particular case, because paragraph 13 does discuss enforcement and attorney's fees that are available in enforcement actions, 6116 does not apply. Thank you. If there are no further questions, I rely upon my briefs. Thank you very much.
We'll hear rebuttal.
Thank you, Your Honor. Justice Lawson, to address that question specifically, 6116 does apply. Case law like Vitale versus Vitale out of the 4th District Court of Appeal says that 6116 only does not apply if there is a contractual provision that allows for the recovery of attorney's fees by the party. Based on our argument, because the former wife in this case cannot recover attorney's fees, because this is a bilateral provision, she can avail herself of a request for fees under 61.16. And as a matter of fact, in the very order that is under appeal here today, the general magistrate who was hearing the case reserved jurisdiction for her to do so. So she actually, as we sit here right now, has the ability to go back and seek fees based on the need and ability of standard pursuant to statute 61.16.
Thank you.
Yeah, you're welcome. To briefly address the public policy argument made by opposing counsel that this wasn't an arm's length transaction, the point is that in these big consumer agreements where with big corporations where we typically see these prevailing party clauses, they are form contracts where they are put under the nose of the consumer and the consumer has no choice but to sign them. And in fact, if we're honest, in most cases, the consumer does not even read them. This is the form contract they need to sign in order to get the product, the money, the mortgage that they're seeking. And it's completely different than a family law contract or a marital settlement agreement where there is a lot of thought put into the negotiation and the drafting of the agreement. And to finish, to Justice Coriel's point, yes, the plaintiff or defendant reference in the statute, that's no more than an identifier, I believe. I don't think it actually does anything to affect the meaning of the rest of the statute, which, as you said, says a party and then the other party. And that is the most important reading of the statute. That's the most important language. And when you contrast that with the language of the provision in this case and the provision of Sackett, where it says that either party or both parties can file these actions against each other. And in fact, in our particular case, both parties actually have filed these actions against each other and sought attorney's fees. You see the contrast between the unilateral provisions that 57105 subsection 7 is meant to address and the bilateral provision that's in this contract and in the contract in Sackett. And for that reason, we ask that your honors quash the decision of the Third District Court of Appeal and accept the decision of the Fourth District Court of Appeal in Sackett and find that 57105 subsection 7 does not apply to bilateral provisions like the one that we have in this case. And I thank you for your time. If there's no further questions, I will defer.
We thank both of you for your arguments in this case today. That is the final case on our docket. So that ends the session of the Florida Supreme Court.